You want a better life. Let's make it real. This is a better life. From scars to stars, from pain to bulletproof, to reach a better life. A better life with you. Talking news, pop culture life, love and scandal, heart to heart. Teresa, better life. Real is where the reset starts. No playing small. We rise, we fall. We laugh, we do it all. A better life is one brave call. Teresa, better life. Let's build a better life. Let's build a better life. A better life. Teresa, better life.
Hello, let me add this to
We need
stage.
to read all the law enforcement reports, right? We need to
Hi,
review
Fearless.
all of the interviews that are likely to come up in that testimony. So we are in the process of determining what reports we're still missing, and there are some still missing, and what interviews
Okay,
we are
good.
still missing. And we are still missing interviews. And we haven't sent an updated list to the state as of today because we don't want to piecemeal it. We don't want to just ask for one thing at a time because we know it's a process to go to the law enforcement partners, get it to SBI, SBI get it to the state. But we are creating a list. And the discovery in this case, the only way I can really describe it is that it is like a living, breathing organism, right? Every time something comes in, we have to check our list, see if it's something that we've been waiting for, something that we've anticipated or requested. So if the court is asking me personally if I feel like I'm ready to render effective assistance of counsel in May at a preliminary hearing, the answer is no. Both because there is not enough time to determine everything that we are missing and get that requested and review it in sufficient time to render effective assistance of counsel, and just the sheer magnitude of what we're dealing with. We're dealing with dozens of law enforcement agencies, hundreds of reports. We are going through it as quickly as possible, but of course, the most important thing to us is rendering effective assistance of counsel. So if the court is asking my opinion of me right now, the answer is no.
So, Ms. Pfister, I appreciate that. When will you be ready? With what you have right now?
With what we have right now, so this is one of those things where you're ready when you have to be ready, right? Based off of my calendar and what I believe I need personally, well, we need the DNA, so.
Well, let's focus
Outside of the
only
DNA?
on what you have, what's before you now.
I would say I need at least 4 months to finish processing what I have, based off of my calendar, my trial calendar.
All right. Thank you.
Thank you.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. I don't know if you recall, it's been a long time, but when we were first setting this prelim, I mentioned to the court that for the months of February and March, I would not be available. I was involved in a murder trial in Summit County. And so for the entire months of February and March, I was not able to work on this case. The trial ended, I think, March 17th or 18th. Then I got sick for like 10 days. So I have not been able to turn back to Mr. Robinson's case until the beginning of this month. In the time that I was in trial, we've had 7 disclosures from the state. Many of those disclosures involve thousands and thousands of pages. One of the biggest disclosures we got was on March 5th while I was in trial, and it consisted of the entire FBI file, which was massive. That's what I've been focusing on the last 2 weeks, reading it as fast as my eyes can read it, because a lot of the reports, I think, that are going to come out through the SBI originated through interviews with the FBI. So I've been trying to get my head around that file. And that's just one portion of one of the 7 disclosures, and there were thousands of pages. And I think I've made it through the FBI file now, but I haven't even touched any of the rest of it. And as lead counsel, I do expect to have at least a portion of the witnesses at the prelim. I share Ms. Visser's concern about, even though there's only 35 exhibits they're going to introduce, that doesn't limit the testimony that's coming in. And I feel like if I'm going to do a job, a good job, that I need to be able to be familiar with everything that officer has touched, and really what the SBI has done generally. We went to examine physical evidence this past week, this week. It took us 6 hours. We did finish what the SBI has. However, we still have never seen the gun. The gun is at Quantico. So we've never been able to look at the gun. I actually think that's really important for purposes of the hearing. So I have some concerns about that. I also have not been able to get into my client's phone. The electronics that we have required an expert because they're so massive. We had to all get these huge hard drives shipped to us from our digital expert. I have not looked at my client's phone, and that concerns me, especially because the state's indicated they may call individuals uniquely connected to my client. I'm not going to say who because I don't want to commit you guys if you call them or not. But we've been given the names of some witnesses they may call, and what is on my client's phone I think is going to be really important. So I would share Ms. Visser's request for 4 months. I will tell you, I handle quite a few murder cases in the state. I think my last murder case that we had a prelim, we continued it, I think, 3 times, and there was 2 terabytes. This case has over 200 terabytes. So I think in the scheme of preliminary hearings and timing, this is not unusual or out of the ordinary for a homicide case in the state, especially one this complex. So personally asking for a little more time, setting the DNA completely aside. Even if they get up and say, forget it, we're not going to introduce the DNA, even if you say I'm not going to listen to the DNA, the rest of it is still significant. I also have some concerns that we do have a notice of intent to seek death with an aggravator. So I assume we're going to go forward with that at the prelim. No one's discussed that. If that happens, that does require really careful review of the scene itself, which I don't know that we're there yet, but we're close. I mean, we definitely have looked at
The
so
scene
many
that's been
videos.
paved over?
I think I've memorized the face of everybody in the crowd. But if we're going to go forward and the court has to make a decision, if you're binding over on whether or not it's capital, whether or not there's an aggravator, that's a whole nother section we have to get into. So for all the same reasons, I would ask for 4 months at least. Thank you, Your Honor.
Thank you, Ms. Nestor.
Seems fair.
Mr. Burt.
Yes. Judge, I've had 2 primary assignments in the case. One is dealing with the media litigation, which has taken substantial amounts of my time. And I'm responsible for putting the hearing on today and working with the experts. And so a lot of my time has been devoted to those kinds of preparation issues. In addition, I've been assigned the task of dealing with all forensic issues at the preliminary hearing. And those efforts so far have involved me sorting the discovery as it comes in, because it's not
There is
come in
no scene,
in
yeah.
discrete packages. Discovery dump 1 might have some DNA discovery in it, and the next time we get something on DNA is in discovery package number 4. So part of my process has been going through everything as it comes in to sort of sort and get organized the various areas of discovery. And so far we have information coming in on the following areas: autopsy, experts, canine deployment, crime scene photographs, DNA, fingerprints, firearms, footwear, laboratory intelligence unit discovery, question documents, state forensics, and trace evidence. So I have set up files for each of those areas. I'm uploading and organizing and reviewing discovery as it comes in each of those areas. We are retaining experts at the point in time when we feel we have enough information so that we're not paying experts to have to duplicate or do discovery review in batches. We're taking on the burden of getting it organized so that we're not spending a lot of expert resources on reviewing discovery.
The media is
So
not
we have
allowed to
retained
show his
the
family.
DNA experts, and we're stuck on that issue, as you've already heard. We've retained a firearm expert who is awaiting the case files from the ATF. We just got in the second to the last discovery batch the autopsy photographs that were produced in September. I think we got those just in March of this year. So those are being reviewed and organized so that we can hire a forensic pathologist who will review the autopsy report and prepare us to do whatever cross-examination we need to do on that
How about a
report.
second
But we
autopsy?
have not yet retained that expert. So that's
I want
kind
a
of an
second
open-
autopsy.
happy to
I
answer
don't
any
trust that
questions.
report.
I don't feel, given the state of discovery and the complexity of some of these forensic areas, that I'm in a position to render effective assistance. The expert, the DNA expert, estimated 6 months. I think if we got the minimal 2 categories of information that I outlined for the court, that we could expedite
Please
that
keep
down
hitting the
to,
heart next to the
approximately
chat
4
so that
months,
the
so that
algorithm
they'd be
will
prepared
tell
in that
people
time
we're
period.
here and
Thank
tell
you,
them
Mr.
to
Burke.
come watch
Thank
with
you.
us.
Mr. Novak.
I've already been told I used too much of the court's time, but I think
But
I can
I
supplement.
need more of this.
I appreciate all the efforts of every party, and I know it's important, and so
It's not a commercial.
time is necessary.
Excedrin doesn't
I
sponsor
appreciate
me.
hearing from you.
I'm not going to represent that I'm
I use Excedrin on a
responsible for
close to
all
daily
of
basis,
the
actually.
motions and pleadings that have been filed, but I've really
They should
devoted
sponsor me.
my time to writing. And obviously, the court has held many substantive hearings on issues so far. Obviously, everything that we write is a collaboration, but I think that the vast majority of the time that I've devoted to this case has been the legal writing and frankly, coordinating the mitigation investigation, which I'm not going to talk about beyond saying I speak almost daily with the people involved in our mitigation investigation, reviewing mitigation materials. That's where I'm focused. And obviously, that's not part of the prelim. So if we were shifting to fulsome preparation for the preliminary hearing over, say, the next 30 days, I would have to basically put aside all of the writing that needs to be done and direction of the mitigation investigation, and figure out where, with my colleagues, they need me to fill in so that we are all constitutionally effective when it comes to the preliminary hearing.
And so if, as it relates to what you are maybe assigned to as it relates to the preliminary hearing, how much time would you need?
I think the estimate of my colleagues of 4 months is appropriate. And I also think that what we are all saying is whatever time our DNA experts need once they see the data that Mr. Burt so eloquently explained, to your honor, we don't have, that's really going to be the controlling time period. We're not, in other words, we're not going to say, oh, our DNA experts are ready, but counsel are not, because I think that 6-month estimate by our expert, which was provided in a declaration, is going to be the outer limit, but that's going to be from when they actually get the data. And as Mr. Burt said, there may be a refinement of that once they see the data that's available to them. I mean, that was sort of a best assessment based on past experience, not based on what the data in this case presents in terms of the challenges for analysis.
Thank you, Mr. Novak.
Thank you.
All right, anything, just turning to the state, any benefit of the record that's needed?
I would just add, I haven't seen everything in the file either. That doesn't stop me from being prepared. This is a massive file. Probably, I don't know, 70, 80% of the file is running down leads that did not lead to any fruitful evidence. And so a lot of what this is categorizing evidence. And
Let us
the
be
core
the
evidence
judge
that's
of
required at
that.
the preliminary hearing has been provided for a long time with the intent that I can
Yep,
help the
agree.
defense. And this is exactly what I said in my
Agree,
letter that I
Cindy.
wrote to them with the witness and exhibit list. I provided very explicitly the witnesses we would call, the Bates numbers of the reports that talked about the witnesses that we would call, including the Bates numbers of the reports of the witnesses we would use 1102 statements for. I included all of the exhibits, the Bates numbers for those exhibits, the dates on which those exhibits were provided for the defense. I see no reason why the defense can't review that material. We could probably review it in an hour or two with them, and they could sit down, look at those exhibits, look at those reports, and be prepared for the preliminary hearing, Your Honor.
Thank you. All right, thank you to all parties. I appreciate that guidance. I've made note of it. As indicated before, we will take another brief recess. We just need to get technology set up to ensure that it's seamless as you're making your presentations. And we'll break, come back at the 1 o'clock hour. Council also use this time to prepare, so when we start at 1, we're ready to jump in. We'll start with defense, and that way we can be efficient with our time. Thank you. Court is now in recess.
So they're taking another 15-minute break here. Okay. Let me see. I want to hear the crosstalk a little bit here until they turn it off. Another donut break. I watched the Karen Reed trial, and you would think that the MSM was seeing a completely different trial than what I saw. Yeah, did they report it quite differently? Karen Reed, that was a wild trial. Do you guys watch Emily D. Baker, Law Nerd? I like her. I wish she was covering this, but she's covering the Corey Richins, I think. Wait, is it Corey Richins? I can't remember if that was over or not. But anyway, yeah. Oh, guys. Okay, so I got to the airport. The flight was delayed an hour. Then a little bit later, it was delayed 2 hours. Then a little bit later, another little delay, and then a full-on delay, which would have made me miss my original connecting flight in Chicago, and would have put me 7 hours to Salt Lake. 7 hours later, I'm gonna mute this. This is buzzing in my ear. Anyway, okay, and my eye infection from the eyelash extensions, guys. Oh, it was crazy hurting. And so I'm like, you know what? I'm going to take this as a bit of a sign and just say, I'm going to not do this, and go back home. I came back home, just laid around with a compress on my eye. My doctor wanted me to see an ophthalmologist, when I had gone. And I ignored that recommendation because I didn't want to. I'm like, I can just do this on my own. I'll deal with it after you talk, because I just had too much stuff to do. So I was going to push through and go, and oh my gosh, I was dying. So I decided to listen to doctor's orders, because he had been recommending me to do a hot compress every 15 minutes on my eye. And I'm like, who has time for that? I can't just do a hot compress on my eye every 15 minutes. I've got a life here. I got to live it. Anyways, I regret not listening. I regret it. So anyway, I have antibiotic drops, and hopefully they don't have to go in and cut this thing open, so it caused like blockages in the ducts or whatever the things are. It was awful. I should have showed you I did show you the pictures of when it was at its worst. Anyways, I'm extremely hurting in my head so incredibly much today because of this pain in my eye. But I'm like, we need to go on and we need to watch this hearing and see what they say. So the judge reiterated that we will not get a ruling today. Unfortunately, I was really hoping for a ruling at least on the preliminary hearing, postponing the preliminary hearing, because he's had that stuff for a while. He could have reviewed it, although I guess he has to listen to their arguments. The prosecuting team saying no, and the defense team is saying yes. Anyway, I'm looking at your comments here. Did you end up watching the first part of it this morning? Yeah, I watched it as soon as it started. Yeah, and was paying attention as I was sitting here going, so I'm sitting here in my studio going, okay, can I pull it together enough to do a live? And things kept happening. I'm like, okay, out of recess, I'll probably do it. But we already saw that one. Air travel. Can you believe it? I guess I don't travel enough to realize how many delays there are. My husband travels a lot, and so he's often got delays, cancellations. He's been stuck overnight at places. And I just always had good experiences traveling the once every few years that I travel. And yeah, so seeing that, I'm like, crazy. How do you pay that much for a ticket? Because it's not cheap. And it already takes a good chunk of your time. You have to be there early and all that stuff. And how do they do this so much? So now I understand the gripes and complaints that people have had that I've heard so many times about travel. And do you know that train travel is just as expensive? You don't save. It used to be back in the day, you saved money going by train. It is not like that anymore. Let's see. Eye pain sucks. I'd rather have a dislocated knee. Oh my gosh. It hurts so much. So there's this clog thing. It's like, I guess I don't know if it's a sty or whatever clogness. It's like inside under here. It's like bulging, awful looking. It's horrifying. Please don't let me go blind. I had the worst dreams and woke up this morning imagining myself having to have this eye taken out and having a glass eye. And then I started thinking, how would I would I be able to handle that well? I'd hope I'd be able to handle that well if that happened. Anyways, I just went through this whole scenario in my mind this morning. No, I have been. I'm using a warm compress now. However, because I was trying to get things done and go live and make it to Utah, I ignored them because I thought my body's strong. It'll do it on its own. And so I didn't do the recommended stuff, and now I paid for it. No, your message didn't push me to go on. I wanted to go. Oh, no, I wanted to go on. And, it's hard to, I frequently want to just pop on a live. But anyway, let's see. One time flying to Toronto, London, we were delayed 15 hours due to the fact that the third hour of waiting, they realized they forgot to book a plane. Oh, no. Yes, trains are expensive. Yes, hot compress. So I did that all yesterday. I did it this morning. And so I will keep doing it after we're done here. I'll go back to doing it. But yeah, next time, I typically just ignore doctors because they are just practicing. They don't know what they're doing. And I feel like I know better. But in this case, I was really humbled. I was very much humbled in that. So I still, my suitcase is still packed it's just sitting there. I just came home and collapsed on the sofa and was like, I'm dying. Apple cider vinegar diluted, eye closed, can help reduce, but also just simply warm saltwater saline. Yeah, so I have the antibiotic eye drop and all the compresses. Salt water, not just water. Oh, okay, salt water saline. Okay. What does the salt water do? How does that work? Yeah, doctors, I just feel it. Most of the time I know more than they do. Because you live with your body the whole time and you know your own body and stuff like that. You know what works and you can, your body has its own intelligence. So this time I really regret it though. I actually make fun of my husband because with his foot surgery, he's like doing everything exactly how the doctors say. And I'm like, you don't need to do that. You don't need to do that. I'm the doctor, not. Okay. So the hearing. Okay. So I took some notes on what they wanted. So the judge was telling them, look, you can't just say you need more stuff. I'm afraid you're going to keep coming back and saying you need more stuff. And they're like, look, no. We need the machine analysis and the sample parameters that were put on there because I guess the input is manual. So you calibrate and set these machines with parameters so that it'll, if it's kind of like our blood test. It's only abnormal if it's within a certain range. If it's within this massive range, you're considered normal, even though you might feel like you're not normal or things that are happening aren't normal, right? So it's the same with this. They wanted and they requested it. So the prosecuting team was saying, you guys didn't tell us you want this stuff. And the defense comes back with receipts saying, but we did. December 16th, as a matter of fact, back when you guys said it was done, we requested all electronic files. And so that included the electronic data and from the analyzer, and the FBI still hasn't complied with the discovery request. So yeah, they're saying, I don't know why the prosecutors would say you didn't ask for what you asked for when they sit there and they have the letters. They know they've been asking for things this entire time. So they need all of that stuff. And the defense attorney said, was that, which one was that? Was that Novak or was that Burt? They're saying it literally would take them one day to do what we're asking them to do. So why the heck aren't they doing it? It's not like they have this long list of stuff that they want. It's pretty simple. It's pretty cut and dry. And it doesn't take that long to get it. So it makes me question what the heck those people are doing over at the FBI and ATF, why they're stalling. Let's see, Cisco, Trans-Siberian, we're going back to the train. Yes, I will take your suggestions and do the salt water. I also have vinegar, but yeah, the prosecution's acting like, but it really annoys me. Yeah, it's let me see. I just got a text. I asked Brandy if she wanted to pop on real quick when they have a break. Let me see if she answered. No, that wasn't her. Okay. Yeah, so them acting like they don't have what they need. And I don't know. I think 4 months, I don't think that's, that seems fair, given that they have to give their scientists time to go over this stuff, all over the analysis, over the reports, all over the parameters. And what else did the notes say? There was something else I put in here. I can't read it. Oh, yeah. And if it's taking them this long, 7 months, and they still don't have it, I mean, they have no guarantee that if they told the prosecution, if they told the judge, yeah, okay, let's do a month, they have no recourse if the FBI and ATF still don't get it over to them. They'd have to go forward with what they agreed to. And did you see the judge roll his eyes? I wish I would have minute markered that, but there was a point where the defense was talking and it looked like the judge rolled his eyes. I'm like, ooh, is he cranky? Is he being like, that was a little bit of a sassy look. Did you guys catch that at all? I'm so happy the ladies were like, no, we can't. Yeah. They were nice. The last one, I can't remember her name, not Nestor. The other one. Anyway, I felt like she was being nice to the judge. She was like, I'm like, oh, she's disarming, because I felt like she was, but the judge seemed cranky. Yeah, it was, I wonder if I can catch that. I wish I had that because it was pretty good. So it was when the defense was talking. Oh, was it Novak? I'm not going to try to find it because I'll get lost and then we'll mess up coming back. It looks like they're probably going to come back pretty soon. Okay, but that was something that blew me away. Did you hear that though about the fact that there's not really a reason because they'll only accept evidence that's in favor of the state? I mean, that's all they want. And I feel like that's why they want to go on right now. They're like, you know what else I didn't like about this is that, so this isn't supposed to be a preliminary hearing. They're not supposed to be talking about specific evidence. So he went ahead and laid out the prosecutor went ahead and laid out his entire case of what they have against Tyler. So I'm wondering then, if I was the defense, first of all, I'd be like, wait. He's sitting here talking about all this stuff that they have that lead them to believe that Tyler's guilty. They laid out a case. Did you guys catch that? They sat there and laid out and basically said Tyler did it again. And the defense didn't come back and rebut that at all. Why didn't the defense come back and say, no, we don't know that that's him. And we don't know if these photos match. Tyler doesn't say he was there or whatever it is, but they didn't come back and rebut any of what the prosecution was saying. I'm like, let me up there. Let me talk. I'll do it. Cocoa Bean. Hi, Teresa and friends. I'm lurking and listening while I work. Send everyone happy, positive vibes. Thank you. Oh, I like that picture. It's so cute. He looks really annoyed after hearing the prosecution walk around in circles with his talk. I had said that his opening statement sounded like he learned from Lori's bio. Hey, Aaron, I wonder if Tyler Robinson was a Jew. If Tyler Robertson was a Jew, would anyone think differently? Huh. That's interesting. That's an interesting thought. What do you think, Aaron? What are you saying? Tell me. What does that mean to you? What are you insinuating? Because I'm not sure that I follow. So are you saying that if Tyler Robertson was Jewish, then Candace would be against him and everyone else would be against him because he's Jewish? Because of anti-Semitism? I think that's what you're saying. What if he did? You tell me, chat. Would that change how you feel about this if it came out and said that Tyler was Jewish? Would that change anything at all? I don't think we're going based on what his religious practices are or his race or his beliefs there. We're just going based on, does it look like this person shot and killed Charlie Kirk? Does it look like they are being honest with what they're telling us, or does it look like something crazy, sinister is going on? And I think the majority of us, that's how we're thinking. Irregardless of anything else, that's all that matters. Was he a furry? Did he love a furry? Was he not? None of that. I don't think this plays into any of it. So no, I would say no. I don't. Yeah, we're going by what we can see with our eyes and what we perceive, what we discern as lies. It doesn't matter whether a person's Jewish or Muslim or Christian or Catholic or Zionist, or it doesn't matter. Even if it was somebody we hated. Well, or didn't even believe in. I can't speak for Candace. She doesn't talk to me like that. But my guess is no. She doesn't base things and from what I've seen and know about Candace, she doesn't base things on that. And she's not anti-Semite. She's anti-Zionist. America first. America first, right, y'all? So I agree. Cindy agrees. Chat, do you agree? I don't think that matters. So Aaron says, Candace was not okay with that crazy liberal shot him. So I'm just thinking if he'll be Jewish or French or any of the conspiracy. No, I don't think he will be. I don't think so. I feel like it's the opposite. I feel like how could they pursue with it, because it would go against their whole narrative, TPUSA. What a weird question. Well, somebody believes that. I think Aaron thinks that's probably the case. Beast, Resident Evil. Yes. Yes. Are you saying, Beast, are you saying it would change your point of view? And what is your point of view right now? What do you think? Is the FBI lying to us? Is the ATF lying? In your opinion? It's not a weird question. Candace was skeptical right away and started blaming everyone except Tyler Robinson because it didn't fit the narrative. I think I was skeptical too, right away. And what added to that, what reinforced that doubt in my mind was definitely how a lot of people were acting over the whole thing. Yeah. I just think the statement, like, I don't think they could have gone after him the same if he was Jewish, like from the USA side. I just don't think the statement, yeah, I don't think that has anything to do with that. No, it's a weird question. Stop racism. Yeah, it isn't about that. I think, Aaron, have you been in here before? I think you don't like Candace. I think you disagree with Candace, whatever. Disagree with her, dislike her, hate her, whatever the case is. I think no matter what, would you take the opposite view that Candace has on anything? Is there anything you've ever agreed with Candace on, Aaron? Do you follow Candace? Have you followed her career? So I disagreed. Well, okay, I won't say I disagreed with Candace. What I'll say is when she covered, what's his name? Weinstein, Harvey. I didn't watch that. It didn't matter to me whether this is going to sound really bad. It didn't matter to me if they were accurate in how they were prosecuting him or the charges, because I felt like what the things that he had done his whole life to the women caught up with them and he got what he deserved eventually. Sometimes justice plays out at a time when we least expect it, in a way that we least expect it. See, my thing is that would TPUSA still push their same narrative if he was Jewish. Oh, yeah. Okay. I see. Yeah. That's a good, I wonder that. That's a kind of a interesting thought. I mean, they do protect their own. I think I totally misunderstood the question. Oh, yeah. Excuse me, guys. Anyway, okay, yeah. I don't know. It's hard to tell, but I don't think we can even think it under those terms, because we believe, and it looks to us like TPUSA did that. So if they did that to Charlie, or was involved, allegedly, if they were involved, and they were either orchestrating it or covering it up, they would have only done that with somebody they disagreed with. You know what I mean? They wouldn't have somebody do it who was Israeli or Jewish. I gotta whisper that. I guess YouTube can hear me and they'll do mean things or something. So yeah, that's kind of a hard line to go down and to think of, because I believe they were involved. So they made sure to choose people who would, a lot of people on the conservative side would agree to push a prosecution and sentence. Let's see. Raccoon City Real Talk. Well, we've got a lot of gamers in here. This is okay. I thought that was a Raccoon City was like, hey, like that's in a game, right? That's in what is that game? There's a video game. Anyway, the big news is that the FBI, CIA, and ATF refused to release the DNA analysis to the defense. Yeah, well, they refused to release only their report. They are anything more than just their report. They said, this is our analysis. This is what we get from the analysis. And that's what all you need. And the defense is saying, we want the underlying data so that our analysts can look at it, run the same tests, put in the same parameters, or maybe they put in narrow parameters, or maybe they put in really broad parameters that would make it come within the range that they wanted it to. They can manipulate that for their own benefit. So if they're the ones who they input the parameters, then they can get whatever results they want out of it. And if it didn't work the first time, let's see, how many times did you input those parameters? How many times did you change those parameters? Because, say, what if they put in a set of parameters, the results didn't come back like they wanted them to, and so they're like, well, hey, let's just tweak this a bit. Let's see. That's what I'm thinking. Resident Evil, yes, or Resident Evil. That's the one. So when I saw Raccoon City, that's immediately what I thought of. Is that referencing the game? So, Fearlessly, you're right, because this was all set up in some way or a form that they wouldn't have set up somebody that they'd have to protect. Exactly. There was a channel that posted a video about Jewish families scamming the welfare. Yes, I saw that, Cisco. This whole town in New York City, a welfare, basically live off of welfare and do that. I saw that. Let's see. That channel got immediately terminated. Oh yeah, I think I saw something about that a little bit ago. The Patreon's gone too. Yeah, I think I saw that. Aaron, why would TPUSA do it? Well, I don't know. Why would I? What are the things I can think of why? Money. Have you paid any attention to what the changes were that Charlie Kirk was changing his mind. It was affecting donations. It was affecting support. It was affecting whether or not they supported the Trump administration's decisions. That's a big deal. The Trump administration needs TPUSA. They needed them there then. I don't know so much if they need them now because TPUSA doesn't seem to be doing that well. Erica Kirk doesn't seem to be doing that well. So yeah, I mean, how many billion dollars? What was it? Was it for 40 million? How much was that money? 40 million reasons why? There was a lot of reasons why they could have potentially been involved. It happens all the time. Do you think, do you believe that big corporations are unethical? Aaron, do you think that they kill people sometimes? Even their own? To cover things up? I know the town you're referring to, they're not doing scams, taking welfare is not, yeah. Are you Jewish? No, it can be. It can be a scam when you take advantage of the system. Erica has the largest motive imaginable in the tune of billions. Yes, was it 4 billion? Do you guys remember the amount? True, yeah. I think Aaron's been in before, and I thought I blocked him, or did I just say go away? I think Aaron might be Jewish or Israeli. Is that true, Aaron? Not that it matters, but you don't like us, so I'm going to help you. Dun da da da. Bye, Aaron. I believe, haven't we seen Aaron before, Cisco? I feel like Aaron has come in here before. I would say more. Yeah. So the one big donor, the DuPont guy, which was the one that they called immediately, and they're like, here's your check. Here's your money. You won. Let me see if I can find that real quick. How much? I wonder if we'll get, I'm going to look it up real quick. Gosh, I'm in the wrong window. Okay, let's see. How much money did a donor give TPUSA after Charlie died? Let me see. That didn't bring it up. Candace said a donor gave 40 million after Charlie died. Let's see if that works. I can't remember the amount. It's not pulling it up. Anybody remember? It was a lot. It was an insane amount. And did you guys see that Erica Kirk, I think it was on X, somebody had posted that Erica Kirk was taken off as a speaker at the Make Heaven Crowded, like some event, maybe was it? Let me see if I can find it. Yeah, the crime scene being paved over in 4 days was amazing. And that's what they're saying. The crime scene, there is no crime scene any longer. I'll bet you Charlie Kirk was cremated. I bet you. So Candace asked that question on X if he was cremated. And then, of course, the influencers who love TPUSA said it's none of her business. But I bet so. I bet so. Well, my point was not whether it's true or not that Jewish people are doing fraud. The point is the violent reaction of, oh, yeah, the YouTube pulling it. The chilling of our speech. I was like, Aaron hadn't been paying attention to anything. He wasn't. Aaron did not. He did not want to hear it. He did not want to know anything. That's somebody who has their mind made up. So I'm refreshing this because it looks like it stopped. Okay, no, I just had it muted. Okay, let me see if I can find this. Did you know? What is really funny is in the history of the DuPont family, the people who own Delaware there is actually Georgeson. No way. Is that true? Where did you see that? Okay, court's back on. Let me take it off mute.
Thank you, Mr. Burt. We'll hear from you.
All right,
Your
Mr.
Honor,
Byrne.
by way of introduction and to expedite things, we've prepared for the court a binder with all the exhibits in it. I've had it marked as A, Defendants A.
All right.
And within that binder, there are 12 exhibits. And I think because of the time limitations regarding the hearing, we do have an agreement that there'd be no objection to introducing these exhibits. And I believe the state also has a report that they want to put into evidence. We have no objection to that. So I'd like just briefly to review with the court what's in this exhibit binder so the court has an overview of where we're going and what the evidence involves.
All right, so Mr. Grunander, I notice you standing.
I was simply going to just indicate that that is an accurate report with respect to the stipulation from the state.
Thank you. I appreciate the parties working together to streamline. That makes it easy for the court, so thank you.
So Your Honor, in light of the agreement, I would move into evidence the exhibits that are in the binder. Exhibit A, it would be A1 through 12.
All right, and per stipulation, they are admitted into evidence and may be published at your discretion.
Thank you, Your Honor. Second of all, we have put on a hard drive that we're marking as Exhibit B all of the PowerPoints that are going to be displayed for the court, all of the scientific studies that are going to be cited by Dr. Ruva, as well as the underlying videos that are going to be displayed. Some of the videos are, because of the time limitations, have had to be edited. So we get to the gist of what we want to show to the court. But the entire video clips media coverage from September 10th through today. It's about 6,000 pages.
I see.
But just in case the court wants to look at any of the material, the actual full context of some of the clips we're going to show the court, it's there. And in terms of what else, so I move that into evidence as well.
So that would be Defense Exhibit B?
Correct.
All right, and
No objection for the purposes of this hearing. And I would just say, Judge, that while these are being received into evidence, the state has no objection for the purposes of this hearing. If we move to another sort of challenge with respect to venue, for example,
I see.
we may have to revisit any sort of stipulation.
Thank you, Mr. Grunander. And just for the benefit of both parties, I meant to start with this. So we have a monitor set up here for a court reporter. I just want to make counsel aware that it could be picked up on the camera, the transmission. So if there's something that should not, please make the court aware and we can adjust accordingly. But I just want to make aware so our court reporter can look and accurately make note of what's happening in court. So just FYI.
Thank you. And Your Honor, just in terms of what's in front of the court in Exhibit A, tab number 1 is the CV for Dr. Edelman. He will be our first witness, a social psychologist and the person who conducted a survey of the community opinion. He's going to talk about that. The survey he conducted is tab number 2. Tab number 3 is his PowerPoint, which is very lengthy, and there's no way we're going to be able to get through it in the time allotted, so I'm going to do the best I can to summarize it for the court. Tab 4 is Dr. Ruva's declaration, and Dr. I'm sorry, Dr. Ruva's, Christina Ruva, RUVA's CV. She will be our second, and we're only going to have 2 witnesses. We're originally going to have 3. We've condensed it down to 2.
Okay.
So you have her CV on tab 4. Tab 5 is the report she submitted in support of the motion that we filed back in December. Tab 6 is a supplemental report that she wrote after the state and the media filed their opposition to the motion. Tab 7 is her PowerPoint, again, very lengthy, and because of its length, we're not going to be able to present the entire thing to the court. 8 is a document that is currently under seal. It's a declaration of Amber Robinson, and the court has sealed that, so one of the issues is
His
whether
mom.
it should remain sealed. And
No,
it relates
open
to
it.
the issue of the privacy prong of the rule that indicates the court has to take into consideration privacy concerns of witnesses and others. So that is currently private. 9 is the declaration of Matthew Robinson, also private. 10 is a declaration of Ms. Nestor regarding some threats she has received. And that's, we're not offering that as private. That's something that the court can consider. 11 is a declaration from a prosecution witness whose name is Samuel New, N-E-W, indicating his objection to.
Maybe it was Aaron who
being
threatened Miss
televised and
Nestor.
The reasons for it. 12 is a declaration of another prosecution witness, James Rawlinson, indicating the same thing. And, Your Honor, just to let the court know, there are over 3,000 witnesses, so we have not been able to survey any of them except the 2 that we're providing to the court in terms of whether they have privacy concerns. When we get to the argument, I'll be addressing that issue, but I wanted to alert the court that we do have witnesses who are, at least these 2 who so far have stated their opinions.
Thank you, Mr. Burke.
So I'm prepared to call Dr. Edelman at this point.
All right, and just before we do, this may not be applicable, but just to be thorough, is either party invoking the exclusionary rule?
Your Honor, we've discussed that, and I think with the agreement with the court that we would not invoke the rule, and the prosecution's expert or witness will be allowed to attend, as well as Dr. Ruva would still listen to Dr. Edelman. I think that would expedite the process.
Thank you.
That's accurate, Judge. Generally, there is an exclusion for expert witnesses. In part, that's the reason for the stipulation. The state's witness is going to be a fact witness, but
Okay.
nonetheless, the defense is not objecting to him being present.
All right, thank you for addressing that. That does streamline things. All right, Mr. Burt, and let me call your
Dr.
witness.
Edelman? Did you get him?
So James Rawlinson is the one who jumped up at Charlie's speech and said, "Freedom, freedom, America, America." It occurred shortly before or right around the shooting, the time of the shooting. Let me see.
Your Honor, there was one other issue I wanted to raise with the court. When the court made its ruling on the 13th, opening this hearing to the public, I believe, if I'm not mistaken, that the court reserved the issue of whether particular parts of the hearing would need to be closed. And there are certain slides, video presentations, that when we get to those, I will be asking the court to take them in camera, explaining why I think so, and we just, for the record, ask the court for a ruling.
Thank you. I
Wouldn't
appreciate
that be
heads up.
something?
Sure.
Doctor, if you wouldn't mind coming forward, standing right here to be sworn in.
Hey, Mr. Terrible, welcome
Go
in.
ahead. Well, either way.
Terrible. Tyler's screwed.
You're just going to stand
He's-
right here to be sworn
yeah.
in, and then we'll have you come to the
It's a long road.
You do solemnly swear that a testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Now you
Yeah.
can sit down.
It should be available to everybody. That's the law. It's the law.
All right, so if you'd like to get seated.
He looks
make
cranky
yourself
today. He looks
comfortable.
crankier than the
You
last
can
time I
have your own
saw
water
him.
bottle, but generally
In
we have
person,
water
like, he
bottles.
seems so
Go
nice,
ahead
but
and
he
get
seems
situated,
a little bit
and then
edgy
bring that
today.
microphone close to you.
Sure.
We just want to make sure that the
Okay, this
audio
is the
record
expert.
picks you up, so
Okay.
if you could do that, I appreciate it.
I feel so tiny in this chair. All right.
All right, Mr. Bird.
Thank you. Tell us your name and tell the court what you do for a living.
Sure. My name is Brian Edelman, and I am a trial consultant based out of California.
And what is your educational background?
I have a PhD in social psychology and then an LLM in international law.
What does a trial consultant do?
So as a trial consultant, I work more with attorneys and counties and other clients, more of as an advocate, I would say. And I do pretrial research such as focus groups, mock trials. I help with jury selection, so write juror questionnaires, oral voir dire questions, attend jury selections, give recommendations in terms of cause challenges, peremptory challenges, interviews. And I also work as an expert, which
Yeah,
is different.
Cisco, you
So
were
when I'm
right.
doing this type of work,
that
it's
guy.
more as an objective person, so I'm not advocating for one side or the other. So that's a different role.
What were you asked to do in this case?
Can you speak in, Mike, I'm sorry.
Sure. What were you asked to do in this case?
So at this point, what I was asked to do was to assess whether or not people in the community are being exposed to media coverage, how closely they're following it, and what their sources are. So not a change of venue survey. A lot of the work I do isn't change of venue. I would not classify this as a change of venue study.
Okay. Now, there's a binder there in front of you. Would you take a look at tab 1, please? Set forth all the cases you've worked on, either change of venue or doing community surveys, the kind that you were asked to do in this case.
Yeah, for the most part. I mean, I'm probably, not all of them are in here, but yeah, these are most of them.
All right. Now, did you prepare a PowerPoint
I
for
did.
this case? And is that in tab 3 there in front of you in the binder?
Let's see. Yes,
And I've informed you we have some time restrictions here, right?
yes.
You think you're going to be able to get through this whole?
I'm going to talk really fast. I've had a lot of coffee, so I think it will be good.
So is the
Okay,
judge.
good. So if I could bring that up.
All right.
I had a lot of coffee. When I'm nervous, I talk really fast. I go fast. Is this, I missed it. I was looking up pictures for you guys. Is this the defense or prosecuting
Okay.
witness? It must be, is it the, oh, who's up there? Is
So
that
Why
Novak?
don't you walk us through what you were asked to, or what you're going to present here in your presentation?
So I'm not going to talk about the social science literature just because Dr. Ruba is going to do that. But primarily we'll focus on the extent and nature of the coverage in this case. And this isn't a change of venue study, so it's really focusing on what coverage has come out of these hearings, more of from the video streaming and video cameras in the courtroom. So not looking at an analysis of the prejudicial nature of the coverage per se, like we would in change of venue survey. And then the second part is the survey that was done to see what impact this has had on the jury pool. Are people following it? What are they seeing? What impressions they have at this point? So I would consider this like the baseline. This is the floor of where we're at right now, and we'll see what happens moving forward. And then the last section, if we have time, talks about some of the challenges cases like this pose when you're trying to pick a jury in a community like this.
Great. So you said on the first area, the social science literature, that's something Dr. Ruba's going to talk about, but did you have one key point you wanted to make there?
The only thing I want to say about it, because we'll touch on it when we get into the media coverage, is, there's a lot of research on this, and the main takeaway I want to talk about is the types of pretrial publicity that are most prejudicial is emotional pretrial publicity and pretrial publicity around the character of the defendant. So all I'm going to say is, because it'll come up later.
Okay. So
I
I'm
mean,
gonna skip
it's going to
ahead.
be there.
Okay.
It doesn't matter. It's there. It's going to be there. That's just the nature of
The
these
extent of the
high-profile
coverage
cases. It
and
happens.
Has
It's
the coverage
just
impacted the jury?
what happens.
Right, okay. So again, this is just looking at two things. Where are we at today in terms of the extent and nature of some of the coverage, focusing on the question of whether or not having cameras in the courtroom is potentially prejudicial, and if it's creating sensational content, or is it more of a neutral
Yeah, I
nature
think
that,
it's the
people watching
prosecution's
live
witness.
streams and things like that? And then what impact has this coverage had so far on the jury pool?
And question 2 is answered by your survey?
By telephone survey,
All
yes.
right. So let's take a look at the first.
Who answers the phone for those surveys?
Okay, so I just wanted to touch on the extent of the coverage. So
Trying
the
to-
data here come from two different sources. The first source is
Who
called
is that?
Newsbank, and that's an archive of newspaper coverage. So when it's looking at the coverage in the state of Utah, there's 831 articles in that Newsbank that are sources that are based in the state. And it's probably a conservative number because it's not exhaustive. There's things that are missed. But I'd rather be conservative than overly inclusive.
Right.
And then Utah County, 697. And I believe it looked at like 15 sources primarily, of 15 newspapers. It also includes Fox KSTU, the local Fox station, and there's 209 news segments that are in that archive. The last section there, that row, is from a Lexis search, which is different, and it captures transcripts. So there's 441 of those that are nationwide, but it is limited. So it doesn't include Fox News, it doesn't include, I think, MSNBC, NBC, so it's not an exhaustive list. It's only certain.
I'm sorry, to include CNN, the major
It has
networks?
CNN, I think it has CBS, NBC, or maybe ABC or something like that, but it's missing some of the networks.
And I told the court that on his thumb drive, or on his drive that we provided, was the 441 transcripts,
Okay.
6,000 pages.
Yeah, that's right.
You've seen that.
I have seen that.
I can't.
Next, I think you're going to look at the nature of the media coverage, and what was the framework you used to do that?
Yeah, so one thing I wanted to touch on is, this is the American Bar Association rule. So
I'm gonna look up
3.6 about pretrial
whose
publicity.
witness
Not
this is
rule,
on the
whatever
Utah site.
Utah one, this is just the ABA. And the thing that stood out to me initially is, when we talk about people who work in, attorneys, people involved in the case, like what they should and shouldn't introduce to the public. And one of those things that are key factors to me are extrajudicial statements that the lawyer knows or reasonably should know, will be disseminated by means of public communications and have a substantial likelihood of materially prejudicing the adjudicative proceeding in the matter. So anything that's particularly prejudicial in nature, you shouldn't be releasing if you know it's going to lead to bias. Examples when we talk about the defendant, when I mentioned defendant character evidence is particularly prejudicial, we have character, credibility, reputation, or criminal record. And then tests and things like confessions, admissions, statements given by a defendant. When we talk about tests, it could be DNA, ballistics, things like that. And then opinions as to the guilt or innocence of the defendant. And then anything they know might be admissible. So this is the stuff I look at. Are things crossing that line? Because those things are particularly prejudicial. And I think the ABA, a lot of that is driven by the research that tells us that.
Okay. We're on slide 14. What does this show us?
So the reason I point this out is because a lot of the prejudicial content that's come out so far that you see in the media and keeps being reproduced on social media, in television newscasts, is what was initially released in this press conference. So, it was the, I guess the indictment or arrest affidavit, and there's a lot of prejudicial details that are distributed in there where it's, a very long press conference. We're literally reading text messages from the defendant to his roommate, and they're prejudicial. They imply there's some degree of guilt in there, and it's reading it, the whole thing, which is then disseminated, and it gets reproduced on TV and reproduced again and again and again. It appears in social media posts, reels on YouTube, and a host of other places.
And does that reproduction include when the coverage relates to in-court appearances?
It does. So, we'll get to that, but the information that was here keeps getting reproduced in a sensational way on TV. And not only that, like he's reading it, but when you see it in the graphics, it shows text message that implies this is the actual text message on a phone that came from the defendant, and it's not. So it's very prejudicial and misleading.
So you say on your slide, this serves as sort of a megaphone and a distributor of certain information.
Yes,
That
and the
is within
interesting-
the categories you set out.
Yes, and when it's being
This is the
distributed, just
defense
to point out,
witness.
it's not like it's only distributed on conservative media outlets like Fox, it's on CNN, NBC, all of the networks. So it's widely being distributed to all types of viewers.
And in terms of other sources of this megaphone effect, your next, and by the way, you've got the actual video of the press conference.
Yeah,
some
this is a
parts
clip of it.
We're not going to play that
Yeah.
because of time limitations, but it's
Right.
there if the court wants to look at it. Are there other sort of megaphone factors here?
Yeah, so this is a unique factor in this case, in the sense that people who are very influential, obviously the President of the United States, or former Attorney General, these are people that have a lot of influence and power, perceived credibility, and they're making
Yeah, that's
strong
Burt. That's Michael Burt.
prejudicial, inflammatory statements, and I think that's unique. I don't usually see that in cases, and calling for the public execution of the defendant before there's been a trial.
When I called him
Things
for
like that are
comment,
unique
he
in
was
nature.
pretty cranky.
Right, Your Honor, this is one of the slides I would like the court to
And
see.
Novak's
and
more
it's,
chill
as he
and
just indicated,
lighthearted.
expressing opinions, strong opinions about whether Mr. Robinson should be executed. So the court wants to take it in public, that's fine, but for the record, I'm asking the court not to do that. I do think it's important that the court hear this, just the tone of it and the substance, I think, is very important for the court to consider. Since we are submitting it, the PowerPoint is on the drive, the court could listen to it outside of the public domain, however the court wants to proceed.
So I'll make note of that, and I'm happy to review that in its
Thank you.
entirety.
If we're not going to play, just one thing that's unique about it, if we're not playing it, is
Sure.
there's inflammatory language in there that also creates in-group, out-group identification. When I think,
Could you explain that?
yeah, so it's like a lot of people identify with a political side, unfortunately. I'm a member of the Democratic Party or Republican Party. I'm liberal, I'm conservative. So I think there's some language in that clip where it mentions, I don't remember the exact phrase, but something about like lunatic leftists or something like
Yeah.
that are doing this. So it creates this, the out-group is dangerous, they're lunatics, maniacs.
You're gonna have
or
that,
whatever
though.
Phrase was used, which creates more of danger, the perception that members of that group, that out-group are dangerous and there's a danger there. So that's something that.
But the
comes up
perception
later.
is already there. It was
And
planted
how
that
is kind of
first, within that first
information more or
hour.
less prejudicial?
Well, it creeps, again, in-group, out-group identification, and we think members of
It's
the
already been
out-group
programmed.
are
It's
not
already
like
done.
us. They tend to, or they're all the same. We attribute stereotypes that, of how those people behave. They're more likely to impact how we see them. You're less likely to have empathy for members of the out-group when group salience is high. Versus members of our group, we see as individuals, we're complex, less likely to be impacted by stereotypes, more likely to empathize with them, identify with them, things like that.
All right. Now, did you actually take a look
Yeah.
at the court appearances that have so far taken place in this case to see what was
The general public's already
discussed
implanted with
so
those
that you
thoughts.
could compare what was happening in court with what the electronic media was reporting was happening?
In terms of the comparison of what's happening and what's being produced? in
Yes.
media? Yeah, I did look at that.
So the timeline, could you explain this, what you have up here?
So this is just a timeline of the hearings that have taken place and like high level what they were. So like the initial WebEx appearance, pretty brief, and you would think that's a pretty neutral, not very significant hearing, and you would expect if you're looking at the media, it should be neutral. It shouldn't be highly prejudicial, inflammatory, since very little happened there, right? And the same thing when you have like the waiver hearing, appointment of counsel. There's not a lot of fireworks. It's not the preliminary hearing. No evidence is being laid out or anything like that. So you would expect the media not to be introducing prejudicial content, given the nature of those particular hearings.
If they were serving an educational function?
If
They
were
need to serve a
educational,
gag order on the
transparent, a
president and
summary of
vice
what
president.
occurred. These are very procedural, technical things. They're not necessarily sensational in any way.
So did you take a look at the first hearing, the initial WebEx appearance by Mr. Robinson?
Right, so this is a brief, short hearing. He's, I think he appeared on WebEx, right? And then I looked primarily at what did that elicit? What was the reaction to the media? Was it kind of just summarizing this is what happened, or was it more sensational in nature?
Okay, so let's take a look at the clip. And this is from NBC News.
You have been watching that court
on that
hearing
date,
for the
correct?
man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there, not speak.
I think we got a problem with the audio.
And we can't see the video.
And this concludes to thank all parties for being here.
Do I need to?
Michael Burt defended the Menendez brothers back in the day.
Let me check and see.
We know what happened to them.
That's in settings.
Is this source, the volume for the source might allow for amplified volume.
Oh, yeah, right, okay. That's what, all right. Let me unplug this and replug it. That's the way it happened last time. Speaker.
Yeah, Michael Burt and Novak are out of California. Pro hoc vice means they have special permission to come and work on this case in Utah.
Okay. Okay, so is this first slide from, it's not in that? All right, let's try that out.
There we go.
There we go. Okay, let me escape. Slide. Okay,
Did you skip the previous,
yeah, let me go back.
19? There you go.
There we go. So is this, as you indicate on the slide?
Not
here,
too
this
much,
is
Jamie.
ABC's
Hi.
coverage of the September 16th, 2025 WebEx appearance.
Yes.
And in this clip, are you picking up the coverage right after the court says we're in recess?
Yes.
Okay.
Are you guys going to show us or what?
I don't know what's going on.
He didn't when I went last month, but the judge sure seems a little bit edgy today. Maybe he didn't sleep well. He does have nice frosty hair. They can, look at all of them. They all do. They go to the same salon.
No, it's not. Getting no audio at all.
Want to try a different laptop?
I'm sorry.
I recommend rebooting the laptop.
Okay.
That's always so frustrating when people are watching too.
Try that. Apologies to the court. Thought we had this set up. Let's do.
He's probably so frustrated right now. He probably just. He's even more cranky. Let's see. Here's your defense team while we're waiting. This is a younger picture of Michael. Richard looks about the same. But Michael definitely is not as young looking right now today. Let's see. Is she defending Corey? Yep. Ooh. Oh, he's cooked. Tyler's cooked. He's got Nestor and Bert. Was that a Chromebook restart?
I've rebooted.
Oh, I feel bad for him.
Say again.
Everybody in the courtroom was like, bruh. I'm sure it's not his fault.
That work?
There we go.
There we go. Okay. Yes. I think we're good. Okay. My apologies. So you're picking this up from the point in time right after they've shown the whole hearing?
Yes.
And this is kind of the aftermath?
Right.
You have been watching that court hearing for the man suspected of shooting and killing Charlie Kirk last week on a campus in Utah. You saw the suspected assassin, 22-year-old Tyler Robinson there.
Why aren't they showing
not
us
speaking,
the video?
wearing what appeared to be some kind of green vest as the judge read out the 7 charges against him, including, of course, aggravated murder. The state making clear that they are seeking the death penalty and putting in place, the judge did, a protective order, apparently at the request of the state, for Erica Kirk, Charlie Kirk's widow. I want to bring in Danny Savalos. I want to bring back Steve Patterson, who's live for us in Utah. Danny, here too, some of the paperwork is just into us on that protective order that the court finds the defendant represents a credible threat to the physical safety of that person here being Erica Kirk. Danny, stand by for a second. I want to go back to Steve Patterson here. And Steve, It has been a remarkable series of developments over the course of the last several hours as state officials, the Utah attorney there earlier in the day described, and the charging documents, some of these probable cause documents showed step by step, almost minute by minute in some instances, how they closed in on this 22-year-old as their suspect.
They did, and in doing so, we got the TikTok, we got the charges, also these, the exchange of text messages between Robinson and his roommate. These are details that we simply didn't have before. One thing that sort of gels with what we saw in the text messages, this exchange again before and after between Robinson and roommate, who believed to be romantically linked, is how cognizant and lucid Robinson appears. And I would say that for looking at this video, although unblinking, so unblinking and eerily at times, that it almost appears like the video is frozen. Just want to comment a little bit more on the physical appearance of Robinson, appearing over WebEx on video. Appears to be wearing what is described to me as a safety smock. We know he's on a special hold, right? They're going to hold him there in a separate unit before they evaluate his mental health, before they put him in maybe a more different location, more general location. They do that as a matter of procedure, right? But it is sort of interesting. He did say one thing, which was his name, which was stated clearly and firmly. And again, I want to say gels was sort of what we saw in that exchange of text messages, because he's talking to his roommate, who clearly appears to have no idea, the roommate, what is going on, or that he is the suspected shooter. And yet he's sort of talking a TikTok of what he has done and why he's done it, and admitting to do it, essentially shocking this roommate through these series of exchanges, which sort of gels with his physical appearance today. Obviously, we also heard during the hearing the Utah County following the course of action to introduce the death penalty as well. That was filed as this was being read in court. So definitely some developments here today. And just the amount of information that we got, the blanks that were filled in.
That's right.
Not only that, but also on the apprehension, the involvement of the mother as well, and sort of bringing him in. And also the physical evidence, the DNA found on the actual trigger of the rifle, which was tied to not only what was found on the screwdriver, but also the towel used to wrap the rifle. So an extraordinary amount of information that we got, especially with this charging document that's now in.
What's also clear from these text exchanges laid out, Steve, is that Robinson had no intention of being caught. And I say that because he said he had hoped to die of old age with this being his secret, according to what the state had laid out in this text exchange. Almost seemed panicked when describing trying to go back to return to retrieve the rifle that he allegedly shot Charlie Kirk with, not being able to do so when essentially caught out by his parents, when his parents approached him and said, we think this may have been you, tried to get in touch with him, tried to reach out. The state says that Robinson suggested or implied that he may try to take his own life here. So you can get a sense of his mindset, at least based on some of these text exchanges and what law enforcement has laid out over the course of some of these documents here. All of it, as we should note, these are the state charges here. It's possible federal charges could come.
Yeah, federal charges possible. One notable sort of omission is we didn't see any federal officials. We don't know if federal charges will be filed, although it's heavily implied that they will. One thing also is sort of the level of deceit, both with the parents. The father did something that sounded very clever. It was heard the description of the rifle that had been described by authorities, federal authorities, state authorities, and that he assumed, obviously with the pictures of Robinson himself on camera at the university, assuming this is his son, tried to get in contact with his son, trying to ask, hey, could you send me a picture of the rifle that I gave you? And of course, the son sort of ghosting him, seeming to imply, again, involvement. And also about the rifle, there was a lot of investigative work to try to figure out, was the rifle traceable? Was it bought legally, illegally? Would have been hard to trace, we now know, because this was essentially a family heirloom, something that's common in hunting families, passed down from grandfather to father to son, and that was the case here. So again, much more stark relief that we're seeing this case in, Hallie.
That's right. Robinson also telling his mother he had been out sick, had stayed home sick over the course of the 2 days that she had inquired about. Steve, I know you're going to stand by for us later on as we get potentially more on this. Danielle, let me go back to you here briefly, because Steve laid out what could come next here. Obviously, the death penalty that the state is seeking, What about this protective order for Erica Kirk? Is that something that is typical in the course of an investigation like this, a prosecution like this?
Sure, yes. As to prospective victims, it's usually not entered against someone's spouse, but it makes sense here because this is not some street crime or a crime of passion. This is someone who was apparently, whether by this defendant or not, targeted. And so it makes sense to say, well, close members of the family may also be targeted as well. So it's not unusual for judges to enter those kinds of protective orders as sua sponte on their own or in response to a request from the prosecution.
Danny Savalos, thank you very much for that. I appreciate that. We have been talking now about the developing news that has occurred over the course of the last several hours, with prosecutors laying out in detail how they say Tyler Robinson carried out this murder. We're going to play a big portion of that in case you missed it earlier. We want to basically roll that tape so you can hear for yourself how the state laid this out. Take a listen.
I wish they'd show us the video.
These are the allegations.
And let me stop it right here. At this point, does she play essentially the entire press conference by Mr. Gray?
Yes.
Okay. And we didn't include the entire 27, 30, or 45 minutes, right? We clipped it to get to the end of the coverage.
On September 10th, 2025, at approximately 12:23 p.m., Charlie Kirk was shot and killed while speaking to a large crowd on the campus of Utah Valley University in Orem, Utah. Police found the suspected murder weapon, a bolt-action .30-06 rifle, nearby. Over the next approximately 33 hours, police conducted a manhunt for the shooter until the evening of September 11th, 2025, when Tyler James Robinson surrendered to police at the Washington County Sheriff's Office.
You have been listening to Jeff Gray, the Utah County Attorney, earlier laying out those minute-by-minute details on how they caught the man accused of assassinating Charlie Kirk. You saw the court hearing for suspect Tyler Robinson live before that. That was that virtual hearing. As prosecutors say, they will seek the death penalty. Robinson will remain in jail, no possibility of bail. He'll be in court again in just about 2 weeks.
And again, just to reiterate, we cut 27 minutes out of the press conference, right?
Yes.
So how does this coverage line up with what was happening in court?
Well, I think, like we said, there's an implication that there was, like, the text messages were part of the court hearings, because he implies that was part of the hearing. And then it's bringing up all of this new information or old information that has nothing to do with the hearing. So it's just rehashing. Let's remind you about the text messages, DNA, the deceit of the dad because he was suspicious of him in terms of the gun, and all of these things have nothing to do with this hearing.
I noticed the reporter, when he put that graphic up of the text, by the way, was that graphic the actual phone of Mr. Robinson? Or?
It's not. No, and it implies, and you see that throughout a lot of the coverage, like text messages. There's YouTube reels where somebody like creates a reel and reproduces text messaging so it looks like it's the real text.
Yeah.
And when he's putting that up there, he
but-
says, as we heard in the hearing, words to that effect.
Yes.
But there was no mention in the hearing of text messages or anything else, was there?
Correct.
Is he confusing what he heard in the press conference with what he thought he heard in the hearing?
Well, I
That's
think
going
he's
to
confusing
happen,
the
though. You
viewers
can't control
with what
media.
happened in terms of now that, there's a belief like evidence is being presented in these hearings that imply guilt when that's just not the case.
So as you say in your slide, is this coverage sort of advancing the prosecution narrative as opposed to an educational function?
Yes.
All right. Did you also take a look at ABC's coverage?
Yes.
And by the way, the last slide was, I think, the longest slide, right?
Show us the video.
All right. So this is the same day.
To thank all parties for being here, and this concludes this hearing at this time. Court is in recess.
So the suspected shooter there of Charlie Kirk, the hearing has now just concluded. We know that the state is pursuing the death penalty here. We have just learned throughout this proceeding that they are going to try to find him counsel. They deemed he is indigent, so they will be providing an attorney for the alleged shooter. And the next time that he will make a court appearance will be September 29th. And then again, as you heard the judge there say, that will happen on WebEx. A couple other things that we learned here throughout this quick hearing is that he will remain in custody without bail, and that the state was also present there, and they asked for a protective order on behalf of Erica Kirk. Of course, that is Charlie Kirk's wife. A reminder to everybody that, yes, he was a conservative activist, but he was also a young husband and a young father of 2 children, and a protective order has been granted on behalf of Erica Kirk.
He's in jail. How is he going to go after her?
Correspondent Matt Gutman, he's in Spanish Fork, Utah, there for us. Matt, thank
That
you
was
here
so
for being here with us.
unnecessary.
And so we just saw this proceeding play out. No surprise, right? This is not the proceeding in which this person would enter a plea. But Matt, prior to this, there was a lot of evidence that the prosecution sort of laid out for the public, including text messages, DNA, things like that, that they do plan to try to present to the judge to be admitted here in trial. But perhaps, Matt, you can just gauge for us, since you've been covering this now for so long. Tell me about your first reaction here in seeing Tyler Robinson sit down there, if you were able to see it, sitting down in this court hearing.
He was sitting down. It was via WebEx, so he wasn't physically in the courtroom, Kana, with the judge. But you could see that people were watching. You could see he was wearing this padded vest, and that's because he's been in what's called special watch in this jail here, which is essentially an isolation. He's being held to prevent him from harming himself or from others harming him. We heard from the prosecutor earlier today in his announcement of the charges that the suspect's mother had said that he was suicidal and that he wanted to kill himself, allegedly, instead of turning himself in. So you see him in that protective garb. The bulk of this hearing that we just saw was the judge reading the 7 charges. Of course, they are aggravated by the fact that the suspect allegedly committed this political assassination of Charlie Kirk in full view of children. So that's one of the things that has enhanced the charges against them, and one of the things that makes this a capital case, according to prosecutors here.
And I'm hoping we can just quickly go through some of those text messages that you mentioned there, again, with this roommate, with who prosecutors say that he was romantically involved with. And one thing they touched on in this hearing, too, Matt, is the fact that in this text message exchange, we're showing some of it, but Matt, they pointed out to the fact that they believe the shooter asked his roommate to delete the exchange and then to not speak with the media, and then it's shown in these charging documents, Matt.
Yeah, we have not seen these text messages. We have heard them for the first time from the prosecutor. They also put out this charging document in which these messages were revealed. And it appears to show this exchange between the suspect and his roommate, with whom he was romantically involved, apparently. And it's very, very detailed. And in the text messages, the prosecutor says that
didn't know
the
this
suspect
was
was
filed
talking about the
yesterday.
murder. Also struck me about these messages, at least initially, is that the suspect appeared to think that he could get away with this.
So the defense is asking the judge to hold the prosecution in contempt of court for violating his gag order.
We've learned through these text messages presented by the prosecutor, when he realizes that he can't get back to that rifle that he stashed
Filed yesterday, and they're asking for all the discovery of their communications.
That he is in trouble. And that's when things start to spiral out of control for the suspect, according to these text messages. And at that point, he does appear, at least afterwards, to talk about being suicidal, not wanting to turn himself in. Eventually, he's convinced by his parents that he should not do any harm to himself and that he should do the right thing and turn himself in, Kana.
Right, and the prosecution revealing this was his
The feds
grandfather's
slapped-
rifle.
yeah.
It was a very important piece of family property.
Right.
Matt Gutman, thank you, as always, for being here with us today. I also want to bring in our ABC
Yep,
News
exactly.
Washington, D.C. Bureau Managing Editor, Catherine Falders, for more on this. And Catherine, again, no real surprises here in this initial court appearance. I think everyone now marking their calendars here with September 29th to see what kind of counsel this alleged shooter does get ahead of time. Also notable, again, a protective order has been granted on behalf of Erica Kirk, Charlie Kirk's wife, throughout this hearing. But Catherine, I think really the prosecution made a huge effort here to lay out as much of their case publicly as they could. And they made it very clear, Catherine, in this hearing that they are ready to give over all of this discovery to the defense, the state really making an effort to have their ducks in a row here ahead of this court appearance.
Yeah, exactly. You did hear them say that, all of that information that they've gathered that we've heard about, obviously, through the press conference earlier in these charging documents. There is a lot of evidence that they have. There's mountains of evidence that they have that we've learned through public documents like the one we received earlier and also through our sourced reporting. We know they're doing forensics, for example, on the weapon that he used, which you just discussed a moment ago. So, yes, they said that they are getting fascinating, Kana, to see him for the first time from sitting there from jail. He stated his name, that clip that you're playing where you hear him talking, that was him stating his name, Tyler James Robinson. And I noticed at some points when the judge said, I'm looking at my notes, but when the judge said to him that he was going to remain in custody without bail, you could see Robinson shake his head yes. When he said that he was going to read the charges, remember there's seven counts here, 6 felony counts. When he told Robinson he was going to read the counts, you could see him shake his head a little bit of movement there, but he hasn't said really anything else, of course, other than stating his name, and he will be provided an attorney. But I do think that it is quite striking to hear and see all of that evidence that it appears that the prosecutors have gathered. Looking at the charging documents again, we of course have been really focusing on those text messages that Robinson and his roommate exchanged. It appears they exchanged on the 10th, so shortly after the shooting. Now, it's unclear whether these are all of the text messages in the possession of prosecutors. We don't believe so. There's probably more, but those were quite striking to see.
So they just want the judge to see all
How does
this.
that coverage stack up with educating
As
the
if the
public
judge
about
hasn't
what was
seen
going
it.
on during the initial court appearance?
Well, I think you can see he's trying to, in the beginning, lay out what occurred, and she actually stops him and says, I want to get to the text messages, and brings it up again, and moves it there,
Right.
and implies again that stuff came out in the hearing. So it's kind of blended, that sometimes it's mentioned in the charging documents, sometimes it's, the prosecution made an effort and implies in the hearing again, in just focusing on the evidence. It's not focusing much. I mean, that's like a 5-minute clip, and there's very little about what happened. It does mention what happened. I don't want to act like they didn't talk about that at all, but they blend quite a bit of evidentiary information in there, and at the end of the day.
And when you say evidentiary information, are you talking about incriminating evidentiary information?
That has not been determined to be admissible or anything, so, right. It's just, here's the text messages, and calling it a mountain of evidence
Yeah.
and all that kind of stuff.
Yeah. Okay.
To thank all parties for being here, and
But also,
Did
you
you also
have a
look
very
at,
stoic,
How CNN was covering this initial appearance?
Yeah, this is the same hearing.
And your understanding is the person in the CNN clip is a former prosecutor.
Yeah, they
who was
overuse that
CNN's
mountains
chief,
of evidence, don't they?
quote, legal analyst, right?
Yes, right.
Okay. Let's take a look at that one. That's your next clip, 24, I believe.
but also you have a very stoic defendant who I was looking to see any emotion that he might be displaying.
Oh, geez.
Hearing that the death penalty may be requested for you is a very monumental seismic moment. He had no reaction, nodding in essentially understanding alone.
And the media knows that attorneys always tell their defendants to not react.
That entails that there might be an element of fear that she is experiencing, or the thought that she wants no contact, either from him or anyone around him, that would make her feel more secure. Of course, she is a mother of 2 young children.
Yes,
You
Jamie, it's
understand that. But here you
right
ultimately,
now.
you've got a speaking, essentially, indictment of sorts from the prosecutor earlier today, which laid out so
I do
much
really want to see the
evidence.
video, though.
It's all allegations, the statements of counsel, not evidence in a court of law. But what can come in a court of law?
Yeah.
Statements of the defendant, including all these text messages.
Well, let's,
So according to CNN in this clip, the evidence that she hasn't looked at is admissible, right?
and again mentions it was laid out today, implying that it was.
Oh, the
laid out in
footage
his
is
hearing
old.
and
The hearing's
discusses his
now.
demeanor. He didn't react
thought you meant
properly
the
according to
court.
her. His body language didn't, whatever the appropriate way to react is. So, focusing on him, focusing on these text messages, calling them admissible without ever.
And I notice in all three of these nationally broadcast clips, there's a real focus on the protective order
Yes.
and tying that to Mrs. Kirk's fears, correct?
Mhm.
How is that furthering the prosecution's narrative?
To me, it just goes to future dangerousness of impressions of the defendant. So it kind of talked about earlier, negative character
Yes,
evidence.
the
is
clips are
prejudicial,
old.
And also we know from the research that pretrial publicity in fact affects verdicts and the perceived credibility of the defendant, likability and sympathy. So it kind of goes to that.
Okay. Did you also look on that, for that court appearance, on what the local media was doing?
Yes.
Right. And before we turn to that, did you also look at how Fox 13 captioned the importance of the hearing on the 16th?
Right. So transcript reveals Robinson's alleged confession to shooting Kirk and messages to roommate with a screen capture of the court proceeding.
So the gist of what happened in court, according to Fox, is the confession.
That's what it implies. Yes.
Yeah. Okay. Now, at the local level, did you look at this clip from
Following
KQTV?
Robinson's initial appearance in court today, we did speak with a body language expert who has been
Body language expert.
high-profile criminal cases across the globe.
Also, Grok says it's not uncommon in cases to have a protective order against the defendant who is charged with violence or murder. The media knows that as well, so they're very much doing this intentionally.
Rossi to prolific serial killers, Ted Bundy, John Wayne Gacy. Tonight, Chief Investigative Reporter Wendy Halloran talked to Scott Rouse, who helped break down Tyler Robinson's body language. Wendy.
Well, Jamie and Mark, Scott Rouse dissected the nonverbal cues, analyzing gestures, expressions, and demeanor after Robinson learned prosecutors will seek the death penalty against him in the assassination of Charlie Kirk.
Tyler James Robinson.
Thank you for being here, Mr. Robinson. I'm Judge Graff.
Tyler Robinson appearing virtually from the Utah County Jail in a suicide robe.
It's really odd behavior for someone who should be
Suicide robe.
stressed in that situation.
Scott Rouse is a world-renowned behavior analyst and body language expert. He holds multiple certificates in advanced interrogation training and has trained alongside the FBI, Secret Service, U.S. military intelligence, and the Department of Defense. He serves as an expert consultant for law enforcement and the U.S. military, among others.
I'm going to tell you from my experience what I see going on here.
I asked him to analyze Robinson's demeanor.
No big, deep breaths. We saw a couple of breaths that weren't deep breaths, but they were breaths from just, it looked like they were almost from boredom. So that was a little bit odd as well.
Rouse says when he looks at people in situations like this,
Things like this, I look for things that are missing, and those are all the things that are missing right out of the gate. And this is odd behavior for someone who theoretically should be fairly stressed at this point.
Rouse says it could be that he hasn't slept much.
Even though it doesn't look like a whole lot going on there, that's odd behavior for a situation like this. I've seen these 1,000 times where someone is being in the same situation, you're talking to them, and they've done something horrible. And they don't know what's going to happen next. They don't know what to expect. They don't know how to act during that. And this guy just looks relaxed.
Rouse recounted what facial expressions he would look for.
And you've got things called adapters where you try to get rid of built-up stress and tension. Don't see any of those. We see a little bit of clenching of the jaw, and his jaw goes over to his left. I think it's his left. And that's about it. In my opinion, he's pretty much resigned to whatever's going to happen is going to happen. There's nothing that tells us he's frustrated. There's nothing in his face from an expression perspective that tells that he's worried or frustrated or angry or anything.
I wonder what they'd say about Erica Kirk's behavior.
And he meticulously watched his eyes.
We can't see his blink rate very well. The blink rate tells us if someone is concerned or thinking about something or is stressed about something because your blink rate goes up a lot. Because the normal human will blink about 15, 20 times a minute. And from what I could tell, it was a low blink rate because I was catching maybe 10 times a minute. It wasn't a whole lot. So I think from an emotional standpoint, he's given up.
Now, Rouse said if Robinson was concerned about something, his eyebrows would raise. He says he didn't see that happen at all in this hearing. Mark?
All right, interesting. Wendy, thank you.
What stands
Stop.
out to you about this?
That's it.
kind of coverage?
That's all I have to say. Stop.
Well, now we're completely speculating with sensational conjecture because he didn't blink properly and his eyebrows didn't go up enough or whatever it is. And now it's creating this impression that this person has no emotion or empathy, like he might fit like I think later it becomes a sociopath, and we all heard the story of they have no emotion and all that. And this is all based off of him watching a WebEx for a couple seconds and just making these ridiculous statements because he's the body language expert now. So he can now make an assessment from this hearing that he didn't respond properly because he's, quote, given up or whatever he said. And this is all, obviously, none of this is informative, and it's all speculation and sensationalism.
And by the way, you're aware of the fact that the court has moved the camera from the front of the courtroom to the back,
Yes.
right? And moving it to the back, does that still allow some room for these so-called body experts to maybe analyze how his shoulder was tilted?
If his jaw doesn't move
too
right,
much, or-
Everyone faces the death penalty differently.
things happen over time. So the fact that anytime there's a movement, it might spur some ridiculous story about somebody's nonverbal language is incorrect, is personally, I think is pretty sensational and ridiculous.
Okay.
Following Robinson's initial
Now, did you also take a look at the September 29th hearing?
Or
Yes.
maybe
And what was your
he
understanding of
knows
what
how
actually
screwed he
took place
is.
at that hearing?
And he's like, I'm probably
So
screwed.
This was primarily from what I remember, it was appointment of counsel in this hearing.
It's called the
Stood out.
waiver hearing. You got on your slide waiver hearing, appointment of counsel.
Mm-hmm.
And again, Mr. Robinson is appearing on WebEx.
Right, it hasn't been in the courtroom yet, still
So-
WebEx.
Was it your understanding at that appearance, counsel got appointed,
Yes.
essentially? All right. So how was that covered, first of all, by Court TV? And before I show you the slide, are you endorsing the criticism that Court TV in the slide makes against the court and the prosecutor?
I'm sorry, endorsing what?
Are you endorsing the criticism that in the slide of the court and the prosecutor?
No, that's just what was said by one of the commentators.
What were you trying to assess in looking at this slide, what the perception of the public is to the in-court proceedings?
Yeah, I mean, I think it's commentary that falls on the sensational side, right? So now it's these people are pandering to the camera and it's creating a performative experience. So it's turning into like outside the courtroom, like a reality TV show in a sense. Like, I don't like what this person said or that person said. So not informative as to what's happening, but it's sensationalism, and it's just the kind of thing you want to avoid.
So let me play this for you, and then I'll ask a question about
TV
it.
Live, Matt Johnson alongside my friend Kelly Craft in today for
Yeah,
Ted
it's
and Julia.
normal. It
Busy
just
day
happens.
here. Let's
It's-
begin this hour in the state of Utah, where the suspect in the Charlie Kirk assassination is due back in court today.
22-year-old Tyler Robinson is accused of murdering the conservative activist during a rally that was held at Utah Valley University. This took place earlier this month.
Robinson is expected to appear via Zoom during that.
Can the judge just say, okay, I get the picture. Can we move on? Like, that's a lot.
Going to hear a discussion
Let's
as to whether or
just
not they
get
want to
to it,
schedule a
guys.
preliminary hearing.
While we wait for that hearing to begin, let's go ahead and take a look at a backgrounder on this case. This is Court TV affiliate KSTU with a closer look at the suspect, Tyler Robinson.
Robinson had confessed to them or implied that he had committed the incident.
From his apartment to his family's home, the FBI and police combed every inch of Tyler Robinson's life. His family expressing to law enforcement that he had become more political in the last few years.
Robinson mentioned Charlie Kirk was coming to UVU. They talked about why they didn't like him and the viewpoints that he had. The family member also stated Kirk was full of hate and spreading hate.
Why don't we go ahead and bring in our guest this hour to discuss as we wait for that court appearance to begin out there in Utah. Joining us now from Los Angeles, California, former Deputy Public Defender for LA County.
Yeah.
Philip Dubé. Philip, nice to see you on this
frustrating.
Monday.
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to
maddening.
approach this case with integrity, with professionalism and civility. We are
It's
truth
maddening.
seekers.
It
We will
makes
aggressively
me
pursue the
mad.
truth in this case. Thank you.
Thank you. All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
All right, and that concludes that hearing. Philip, let's go ahead and bring you in on this.
The only criticism I have was that those closing words about how we're all here to seek justice, like the warriors of justice. Attorneys and judges don't speak that way in open court. It's presumed that everybody will act with integrity, with honor, and to articulate it on the record, in my opinion, is pandering to the cameras.
All right, Philip, so
You're familiar that one of the criticisms of the court coverage in the O.J. Simpson case was that everybody, including the judge, was pandering to the camera. You familiar with that?
Yes.
And this guy from L.A., he's probably familiar with that case. He's accusing the court and the prosecutor of pandering to the camera. And then the first part of the video, where they refer to the backgrounder, are you familiar with what's referenced there?
Yeah, again, it's kind of going into the background stuff again about evidence and then jumping in while they're waiting and so on, and then jumping into that.
And who is giving the backgrounder there? What the clip is of Governor Cox, is it not?
Yes, the governor. Yeah.
Okay.
Yeah, reading
So-
another press conference.
So that's a sort of an incriminating narrative. And then the second part of it is, what is the perception of the public
They are.
to the court proceedings being televised? And at least according to what Court TV is putting out there,
Oh, that it's a show. It's
We're
pandering to the camera.
pandering to the cameras.
Yeah.
Does that further the reputation of the judiciary, or does it detract from it?
Is it what?
Does it further the reputation of the judiciary, or does it detract from it when the perception is right or wrong? And I'm not in any way endorsing what he's saying, but in terms of what's getting put out there to the public.
I think it creates pressure on everybody to have cameras in here, from the jury to everyone involved. I think this is a very high-profile case, probably one of the more high-profile ones I've ever been involved in. I think there's pressure on the prosecutor, the jury, everybody involved in this case. There are a lot of people watching, including very, the executive branch, everybody's involved. So I think just those comments and everything else is just pressure to me.
But those kind of comments, like a comment that a prosecutor is pandering to the camera, if that gets to prospective jurors, and that prospective juror is sitting in court as a juror and is asked to evaluate the arguments of a lawyer, and he or she already has a preconception that, oh, this is a guy or this is a court that is pandering to.
Okay, but Michael Burt, OJ was acquitted. Karen Reed was acquitted. I believe it had large part to do with other people like us being involved and watching everything, listening to everything,
Sort of capsule. of
reporting
what the
on
hearing was
everything.
about, The appointment of counsel hearing. What was their headline?
Yeah, so confessions.
Obviously
being
not in
made
the
his
OJ case,
grandfather's
but
rifle. This
still.
is the evidence so far on the Charlie Kirk shooting suspect.
What did confessions and DNA have to do with what was happening in court on the
Nothing.
29th?
And again, this is just, in every hearing and everything you see, it triggers the same information and the implication that this stuff is part of the hearing. So people aren't necessarily watching the live stream. A lot of times in these courts, you're watching the coverage of the live stream, not the live stream itself. Like in the survey, not a lot of people, it's like 25% watch the live stream, but people are seeing this stuff on TV, and this is what the media coverage is. So it's not showing the live stream, it's screen captures, it's like a short summary of what happened, and then going into this information and the perception that this was evidence presented in the hearing when it was not.
And the substance of it, confessions, DNA,
Exactly.
is sending a message, is it not?
Yes.
Now,
It's already done.
is
Just
this,
stop.
again, on
Let us in.
December 11th court appearance, I want to ask you how Fox News covered it, and with one of their talking heads
Just add
here.
to our comments about his demeanor in court earlier. We talked a little bit about don't try to understand the mind of a monster. Well, we do know a little bit about the mind of this monster, and that I believe he's incredibly proud of his handiwork. It makes us think a lot about Luigi Mangione. These two men inscribed notes on the bullet casings that they used.
Okay, the benefit though of him doing this is that he gets to basically say for the public that the media is skewed. So he gets to come out and rebut that in a big way that he wouldn't before objecting to cameras being involved. I wonder if they truly believe that it shouldn't be allowed, or if they just want to put on this show for us, for the public, or if they really truly believe cameras shouldn't be allowed. Or if this, do you think this is just strategy, or do you think they believe cameras shouldn't be allowed?
Trouble.
Tell me in the chat.
Yeah, I think that's exactly right, as Josh put out. When you have cases of this kind, you are off the map. You are where monsters dwell, to use pirate terms. This is where you find monsters, are in these cases. And you find people that don't think the way you do. This is one of the reasons jurors often stare at defendants whenever they can get away without being impolite. They look at these defendants to try to figure out something not just about them, but themselves. How can someone go off the map to this degree? The evidence here is overwhelming. And a lot of attention is likely to be what possesses a person like this to treat someone like Kirk as a trophy. And that is what happened.
Well, if it's true that he did it and he gets convicted of it, I guess you could say that, he thought in his own twisted mind that it was something that he needed to do, and you could never understand, as you were pointing out earlier, Professor, Trey was pointing out, the person who drowns their children and the person who bludgeons someone to death, you could just never get inside that mind to even begin to understand what's going on.
Is it your understanding?
That's right. I think that's absolutely true.
Yeah, that does it for us here.
You're understanding the first commentator, the first talking head there is an ex-prosecutor, right? And is he sounding like a prosecutor talking about the mind of a monster?
I mean, to me, it's more sensationalism. First of all, again, negative character evidence is some of the most prejudicial pretrial publicity that you can have, emotional, negative character evidence, particularly in death penalty case. And you're hearing mind of a monster, he's a trophy. I mean, he's smiling. Like, what is the basis of any of this? Like, there's nothing from that hearing or anything that is relevant here. Like, this is just pure speculation and sensationalism.
Now, the second speaker, the guy who chimes in and says, yeah, this is, the evidence is overwhelming. At this point in time, had any evidence been disclosed to anybody, either in the court hearing or, as far as you know, any place else?
The only thing we've had is a press conference with the charging document.
So the second guy, a law professor from Georgetown in Washington, what would have been the basis for him commenting that there's, all kinds of evidence here, agreeing that we're dealing with monsters? What is the factual basis for that?
I guess from the charging document.
Well, if this is strategy, I think it's good.
Just add to
If
our
this is
comments on
strategy just to point out to the greater public that what the media is doing, do you think it's good? Do you like it, or do you not like this strategy?
And this is from the ex-FBI agent. Is there talking head here?
Yeah, and the sociopath
reaction
stuff
so far.
feeds into what we've heard earlier.
Well, my first reaction is looking into the courtroom and seeing what's happening. Again, talking about Robinson, it's disgusting. He's a true sociopath. It's someone who has absolutely no empathy. They have no remorse. They have no conscience. He killed somebody. He doesn't care. He's smiling. But again, that's not going to serve well. When the trial comes to pass and the death penalty is on the table, again, jurors will not be okay with that. The other thing that I think is very important to understand is that working with these victims, I know myself when I was an FBI agent, I wanted a victim-centered approach. Erica Kirk and those in her surrounding sphere, her family, her loved ones, Turning Point family, they are the victims of this. And frankly, the American people who have
Turning
had to watch
Point
this
family.
absolute catastrophic tragedy.
They're processing their guilt. They're processing their guilt. They're processing their guilt. They're processing their guilt.
And I do think it's very important in this process that you are working closely with the victim, and I assure you that they are. She deserves to know what is going to happen. She didn't wake up one day and become a legal expert and a law enforcement expert. She is the victim of this most heinous crime. And again, God bless her, God bless her family. And I do appreciate that there are people that will step up to the line and will hold her hand and walk her through this process, as that is what she deserves. There's several other things that come to my mind in this trial, but it does come down to the judge's decision. But the conspiracy theories are despicable, they are disgusting, and you are profiting off of someone who has been murdered. And that is wrong, that is sick. And if you think that you're helping justice to be served, you are wrong. You are doing no favors for the prosecution team. There are solid law enforcement officers on these investigations. Trust that they are doing the right thing for the right reason. Look, I come from the FBI. I understand why people are in a position where they do not always trust the criminal justice system because of things that we have
That's
seen
my
in our country.
soundbite.
But rest assured,
I made a soundbite
on
to
this
play for you guys
investigation, no stone will be left unturned.
of Erica
All eyes
and
are on this,
Andrew.
and there will be no mistakes made. And so please do not take the liberty to go and make up and fill in the gaps where you do not have answers. It is inappropriate. You are not helping things. You are making things worse. And if you want justice to be served, you need to let the process work the way that it should and stop putting these lies into people's minds, because you are hurting people. And most of all, you are hurting Erica Kirk, her family, and her loved ones. It is unacceptable. It cannot be tolerated. And anyone that has a clear conscience about making money and creating clickbait, that is sick.
Yep.
Yeah,
It's sick.
Now, what
Except if
about
Erica
that
does it.
segment educates the public about what was happening in
NTP
court
USA.
on December 11th.
Yeah, clearly it's not, and it's in the backdrop of you see just, in the corner of the courtroom, but it's just, again, an opinion and a diatribe basically about, there will be no mistakes, no stone will be left unturned, and that the prosecutor's doing everything correctly and so on, so.
Does the literature tell us anything about what impact it has in terms of who the person speaking is? Like, this is an FBI agent, ex-FBI agent. So do people listen? Does research say anything about that?
It's just like a source credibility question. Law enforcement, people know who she is. It's not always the case that a stranger is seen as credible, but definitely when you hear more prominent people saying it, absolutely. And just you think about how people passively consume information. So you're not really, when you have this on, you're not necessarily highly critical of what's being said. It's passive consumption of news. So you're not questioning the source per se.
That's it.
Or thinking,
That's all I have to
this
say.
is
Stop.
maybe not appropriate. None of the evidence that's presented yet. It's editorial masked as news, basically.
I notice in this clip, she's critiquing the conspiracy folks from trying to profit from their commercial ventures.
That would
And as
be
she's making
awesome.
this critique, you notice the advertisements running on the side of the video. You get a loan for a car loan,
Yeah.
4.99%.
Like, remember the that was easy button? What was it? Staples? That was easy.
Yeah.
Monetizing it.
We need one of
Is
those
that
in court.
typical of the coverage you're seeing here? In other words, especially on the social media, if you go to social media and try and pull up these clips, you get the clips, but you get a lot more, don't you?
Yeah, you're always going to get ads on social media. That's how they make money. Are you asking about more like in terms of how, like what surfaces and what becomes viral, or?
Well, we'll get to that.
Okay.
That's a separate issue. Okay.
Oh,
This is I'm going to skip
And
that
accused
one.
of assassinating right-wing political activist Charlie Kirk is
Was there also at the December 11th hearing quite a bit of focus on the tie that Mr. Robinson was wearing?
Right. So to me, the thing that stands out is you could see the impact of some of this stuff that's irrelevant. So there was a reference to his tie, and it was like trans tie, and then
A trans tie.
whatever that is, and that becomes a search term. So people want to know more about that, or just following his court appearances and so on. So people are more engaged. They're actively searching, which is different from passive consumption.
I'm going to search trans tie right now and see what I find.
And just to be clear, I don't. There was an increase. I don't know what the numbers were before, but yeah, there was.
This is the first I'm hearing about a trans tie, guys. How about you? Did you hear
I
that?
don't mean to interrupt, but I just want to give you 45 minutes remaining.
Somebody just passed me a note.
All right, good deal.
I
Thank you.
got it. Thank you.
And the country, even the world, watching as Charlie Kirk's accused assassin made his first in-person court appearance today.
Is this another segment from our body language expert?
Yes.
Where he talks about he didn't see any grief muscle?
Yes, so
What is
apparently.
a grief muscle?
Do I know what a grief muscle is?
A grief-
I don't
ask
know. So
Erica.
apparently
She probably
the
knows what a grief
wasn't
muscle is.
Functioning properly to imply grief by looking at the clip.
So, and that was the focus of the coverage? It wasn't who got appointed, who the lawyers are, what the next procedural step is, whether he was showing a grief muscle?
Right. So again, we're just back to this conjecture.
Are they saying grief
nothing
muscle?
interesting happened in this hearing, so let's find something interesting to talk about. And it's staring at the defendant and making an assessment of what he's thinking or whether he has grief for what he did based off of his grief muscle, whether it was, I don't know.
What's a grief
doing the right thing.
muscle?
I don't know.
Okay. Was there also in this hearing sort of a focus?
Is that
on
what
a high
Erica's
level of
flexing all this
security was
time?
necessary
Her
to
grief
manage
muscle?
Mr. Robinson?
Yes.
And the local KT,
New video
They really
showing what
are.
we believe is Tyler Robinson's police escort leaving the courthouse in Provo just in the last hour. Robinson accused of murdering Charlie Kirk during an appearance at Utah Valley University back in September. Thanks.
and what kind of
Guys, when I
message
put up an
is that
image, does
sending
it
to
still
prospective
allow the
jurors?
sound to
Well,
come
I think in
through
a case
for the
like this,
video?
like I could see it creates anxiety among prospective jurors. Like this is dangerous potentially. Like there's always pressure, on a high profile case in terms of juror serving, and then adding cameras to the courtroom, risk of somebody being disclosed as who they are. And then you have, news stories about SWAT teams and all these things just to kind of at the courthouse. I mean,
And how about the inference here that Mr. Robinson has to be coverage then cause responses that sort of are connected with a court appearance? And in this case, you have the court appearance on the 11th, and then 2 days after, is there sort of a responsive appearance by Mrs. Kirk to the events that happen in court regarding whether the defendant should have discovery or not?
right. Yeah.
So was this
Thanks, Cisco.
coverage on December 13th a nationally televised town hall?
It is on CBS.
Let me play you just a little segment of that. And I have a question.
What is going on? Why are there so many conspiracies spreading about what seems to be a pretty open and shut case?
This is the first time that we have seen evil on display where we have social media at our fingertips. Something so evil that happened, people are wanting answers immediately. They are wanting to figure out how to wrap their mind around this. Egyptian planes. Egyptian
Do you
planes.
believe that Tyler Robinson murdered your husband?
Yes, I do.
Yes, I do.
Why do you think it is so hard for so many people to believe that reality?
Because it's too simple.
You're too simple.
Again, everyone always has to think there's more to the story. Well, sometimes there's not. I've seen the autopsy report. I've seen our case pulled together. I've been in constant contact with our lawyers, the prosecuting team.
Okay.
I've seen it all.
Our
And I'm gonna
lawyers,
tell you
her
this.
lawyers are the
Why in the
prosecuting
world-
team.
Why should we, prior to the trial, lay all of our hands and cards on the table for the defense team to see, to somehow then, I don't even know what they would do with it. But what I will say, and I want to get on the Egyptian plane thing, we'll take a flight on that for a second. What I will say is what I'm worried about, and I'm fascinated, just from a legal standpoint, to see how the United Healthcare trial pans out. And I say that because this is the first time where we are seeing the implications.
You're talking about Luigi Mangione.
Correct. I prefer never to say any of their names. They do not even deserve the ounce of oxygen and breath out of my body. But what I mean is it's fascinating to see how social media will impact that court case, just how it might impact mine.
Are you nervous he's not going to get a fair trial?
I'm nervous that there could be, they'll say we can't find a fair jury. Like they're going to taint the jury pool. And in that case,
That's how widespread you think these conspiracies have gone.
Yes.
That's how mainstream they become.
Okay. Egyptian planes?
So one of your categories was inadmissible evidence, right? And I know you're not a lawyer, but you're generally familiar with, there are certain things in a penalty phase of a capital case that a victim impact witness can say and certain things they can't say, right?
I don't think
Like
it's a
you can't
mistake that
express
she
opinions about
said
the
her
defendant.
attorneys, their attorneys.
Why is this sort of coverage prejudicial in relation to her commenting on court appearances and whether Mr. Robinson should have the benefit of discovery and her opinion about guilt and the narrator's opinion about the evidence being overwhelming?
Yeah, so I mean, I think there's a lot there. I think one, obviously, there's a lot of empathy for the victim's family, and I think that's very appropriate. So she's a credible source, I would say. I think it's not ideal to have a victim saying that due process shouldn't be complied with, the idea of discovery, and why are we sharing, exchanging information, which is the way that due process works. And then the references, I've seen the evidence, I know, it's an open and shut case, essentially commenting that he's guilty and the evidence suggests that, would definitely be prejudicial and create a presumption of guilt among prospective jurors. So it's kind of like, a lot of that, I think the thing about the conspiracy theories, which are, this is not the first time, I mean, if you look at like the DePape case, when, David DePape attacked Paul Pelosi, trying to kidnap Nancy Pelosi, and Elon Musk was spreading rumors about his relationship with the victim and implying they had all of that. So it's definitely not the first time. It's unfortunate it happens, but it happens a lot.
Okay. Now, you have many more examples in these clips of similar things,
Yes.
right? The basic point being, we're not getting information about the court proceedings, educating the public about how the law works, but we're getting a lot of opinions going to the issue of whether Mr. Robinson is guilty or not.
Yeah, and I'm not saying this was triggered by the court hearing. I mean, I get it was in the sense that she's commenting on what happened.
Right.
Yeah, so, sure.
So I want to talk to you about and we're going to skip the other examples because we're running out of time here. Let's talk about your survey.
Okay.
So walk us through that. First of all, what was the methodology of the survey?
Sure. So again, this isn't a change of venue survey, but it follows the standard practices put forth in the ASTC, American Society of Trial Consultant Professional Standards. So we're using a random digit dial technique. Everybody has a known chance of being selected. So it's not a text message sampling approach or email or anything like that. It's phone calls, cell primarily.
This is its focus exclusively on Utah County.
Yeah. So they have to be jury eligible. So they have to either be registered to vote in Utah County or have a driver's license with a Utah County address on it to be included. And then the survey is designed for, initially, you're just capturing general impressions of the criminal justice system to get people familiar with the study. And then we're going, for this one, it's case awareness, like we would do typically, case recognition, prejudgment, just to get a feel of what's the baseline, where we at today in terms of that question, a fixed opinion question. I call it like a presumption of guilt question. Would the defendant have a difficult time convincing you that he's not guilty? So it puts the burden of proof on the defendant. And then where their source of information is, like is it getting it from local news, social media, national news, things like that. And then a couple basic recognition items, how they watched streaming, which was probably, if I did another survey, I probably wouldn't ask it that way, because I think based on what we saw, like people aren't per se seeing streaming of the hearings. It's the commentary and post-hearing stuff that's really coming out from that. Whether they knew about a confession, I think it's probably better text messages, because that's primarily what we're talking about, and a few other things. So capture that.
What were the key findings of the survey?
Yeah, so high level, so the recognition rate is pretty much everyone, 99%. This is based off a sample size. It's a smaller sample. Again, this is just a snapshot of 200, not the typical 400 that we would do like in a change of venue survey. And then guilt was high, so 64% believe that he's guilty of murder based off of what they've read, seen, or heard about the case. Only people that answer that question are those who know about the case. the 3 people that didn't know about it didn't answer that. Only 7% reported that he's not guilty. That fixed opinion question, you can see over 50% already believe that the defendant would have a difficult time convincing them that he's not guilty. And 35% believe he should be sentenced to death at this point. And 65% have a somewhat or very negative opinion of the defendant, which fits into all that negative character evidence that we just walked through for the last.
So based on the results of this, would you conclude that there's been so much publicity in this case that it doesn't matter whether we get any more because the jury is already, or the jury pool has already been so tainted that adding more to it is really not going to change the equation?
So the idea is Utah County's so saturated that you can't get a fair trial here, so just
Right.
play
At this
more
point,
coverage?
it's so saturated, the court should do nothing to try and control the publicity and, because it's basically a done deal.
Well, a couple things. One, there's also a lot of media coverage coming out of this in Salt Lake City, which would be the largest county, which is where you would typically move it to. So then what you're saying is, well, there's so much coverage here, let's just have a free flow of sensational, prejudicial media coverage. And then down the line, when it's time for a change of venue, you can say, well, there's nowhere to move it because Salt Lake City's just as bad. So I guess you're sorry. So there's that as my first reaction to it. And then I think, look, this is the baseline of where we're at. So you still have, like for the death penalty question, it's only 35%. You're not seeing above that 50% mark yet. We don't know, a lot of it, a big one is case knowledge. So you might find that recognition rates are high here, and I'm sure they're high in Salt Lake City and everywhere else, but it doesn't mean people identify with the case, went to the university, have personal connections, know all the case-specific facts. We don't know any of that yet.
So in your survey, only 35% of those polled.
Yeah, I think that was smart of them
indicated
too.
that Tyler Robinson
Fearless.
should be sentenced to death if he's convicted.
At this point, yes.
And in terms of whether he was guilty or not, you've got 64%.
Right.
Okay. What else about the survey?
So as you'd expect, people are following the case, so people are following it somewhat or very closely. Sometimes in big counties, those numbers are lower because you'd expect in big counties there's so much else going on that it takes a lot for a case to capture people's attention, unlike smaller communities where they're shocked and they follow it very closely. Kind of back to the Koberger case in Idaho. And then you can see everyone's talking about it. So 96% reported that they are talking about the case or they've heard others talking about it in person or online, which also suggests that the big county is taking on characteristics of a smaller community. And you, in terms of source, so 53% are getting the news about this case from social media, and we kind of skip that, but there's a lot of sensational stuff that's being created and clips and reels and inflammatory comments and screen captures from these hearings with comments on them as well. And then people have seen something on social media about this case, 69%. And then they've seen something on YouTube, 34%. And then 45% have seen something about the case on local television as well.
Nobody watches TV anymore.
What is this slide show?
Yeah, so just high level, again, this case is capturing this community's attention. Despite the size of the county, 99% recognition rate. That's very, very, very high. I don't see that very often. And they're following it somewhat or very closely already, and nothing's really happened yet. We haven't had a preliminary hearing. We haven't had the big things happen. We've had pretty procedural hearings about, counsel in terms of gag orders and things like that, and they're already following it closely before the really sensational stuff starts coming out.
Okay. I think this is summary of what you've already said, correct?
Yeah.
So you mentioned this before, but in terms of where people are getting their information from, are they picking this case up from watching live stream or through other sources?
They are not. So if you go back to the prior slide, which is from the survey, this is
Why aren't they
specifically
showing
on
us the
case. They're
slides?
Picking it up from social media, local television. Those are the big ones. They're not watching the live streams. And I think it was like 25%.
Hit the
said
heart,
they've seen,
guys.
like a clip or part of the live stream, but they're seeing news footage on local TV, which we already went through, that has prejudicial commentary about these hearings, whether it's the body language expert or the lip reader or any of this stuff. All that stuff is coming out in those sources, and that's what they're saying.
Okay, I'm afraid I'm going to have to stop here. I hate to do it, but I have to. So,
Oh, I hope the prosecution doesn't go very long because they have a whole other witness. Or is that their time? Is that their time for just one witness? Because they wanted to have somebody else, another witness come on. The defense does. They have two. I think this is just one witness. Who's the other one?
Good afternoon, Dr. Edelman.
Good afternoon.
You mentioned that in your employment, you work as a trial consultant.
I do.
And with respect to that, it's more of an advocacy-related position.
When I'm wearing that hat, yes.
When you're wearing that hat. And this hat, you're more of an objective witness.
Absolutely.
Correct?
Absolutely.
We've talked a lot about today, you've talked a lot about today, we've seen some slides about the negative pretrial publicity towards the defendant.
Mm-hmm.
Did you research negative pretrial publicity towards Charlie Kirk?
I'm
as part of your
familiar
analysis?
with it, yes.
Did you research it as part of this assignment?
No.
This employee? Did you do any research with respect to negative pretrial publicity towards Erica Kirk?
Towards who?
Erica Kirk.
I did not.
Are you aware of the negative publicity that's out there?
I'm aware of the awful conspiracy theory stuff.
Okay. What about, did you research negative trial publicity towards the prosecution's case?
I've seen what that stuff is, and most of it is not from what would be considered mainstream sources. You're talking about people who support conspiracies all the time about windmills killing whales, and that Winston Churchill was the true villain in World War II, so I don't put much stock in that kind of stuff. I know it's out there. I don't think it's comparable.
Okay. What about pretrial publicity, positive pretrial publicity towards Mr. Robinson? Did you look into that?
No, and I don't think there's much of that.
But you didn't specifically look into
Yeah,
it?
No,
Christine
and there's social
Ruva,
science literature
they
on
have
that positive pretrial publicity
Christine.
does not mitigate or eliminate the effects of negative pretrial publicity.
Are you familiar with Professor Christine Ruva?
That's her research?
Her research?
Yeah.
Because she would say otherwise, wouldn't she? That
Well, she
positive pretrial publicity towards a defendant would tend to mitigate?
Positive mitigates? You're saying she says that?
Sure. That positive pretrial publicity towards a defendant would tend to mitigate guilty verdicts.
There's very little pretrial publicity that tends to be positive, and from my experience and what I've seen, no, it does not. You have a mountain of negative pretrial publicity, and you might have 3 stories that are positive. That does not mitigate a mountain of negative pretrial publicity.
Okay. But it would depend on what
Yeah,
that
Cisco,
juror was
they get
exposed
paid
to,
for their
correct?
time.
What he or she
The
paid
experts
attention
do.
Most of the pretrial publicity in cases like this is negative, so if you're implying that it's balanced, I would say absolutely not.
Okay. In your survey, I'm
No.
going to turn to a few of these questions. I believe it's number 2 in the binder there that you have.
Yeah.
That made me laugh.
The question was asked on question 6A, if you want to go to that
Give me
question.
1 second here. Which tab is it? Sorry.
I think if you go to number 2.
Yeah, I read that,
tab number 2.
Fearless.
Okay, got it. Which question?
6A.
6A. What 3 words best describe Charlie Kirk?
Yes. You identified, there were a number of respondents that had a negative attitude towards Charlie Kirk.
Sure.
In
I
your
think so.
survey, correct?
I think that's fair.
For example, multiple people referred to him as a racist, correct?
Okay.
He says, okay.
This is your survey.
Yeah.
You-
Again, the question above that is 64% or so have positive opinions of Charlie Kirk. So you can cherry pick comments in there, but in general, overall, people have positive opinions of him in this
But
community.
there are people within this community that have a negative attitude towards Charlie Kirk.
Yes, I'm
Correct.
sure, and nationally.
Okay. He was called inflammatory in your survey, correct?
Inflammatory?
Uh-huh.
Which comment? Oh, that's what someone said?
Yes.
Okay.
As a misogynist?
I'm not disagreeing with you. You could cherry pick as many as you'd like.
Asshole? Harmful?
Mm-hmm.
Did people respond like as if he were that he's a bully? Did you see
Okay.
that? A bigot?
Okay.
Homophobe or homophobic? Multiple people put that.
Okay.
Divisive? Prejudice?
Sure.
Evil? On the other hand, you asked what 3 words best describe Tyler Robinson, correct? And that was question 5A.
Yes.
And isn't it true that a number of people responded with not guilty or innocent until proven guilty?
Sure.
Okay. We would like people to respond that way, correct?
I what?
You would like someone to respond that way.
They can say whatever they want. Again, this isn't a change of venue survey. This is just measuring awareness of the case in where we're at today.
Okay. Multiple people responded with respect to what 3 words best describe Mr. Robinson as scapegoat, correct?
Multiple? Out of the 200, how many you got there that say that?
More than one.
More than one?
At least more than one.
I can see plenty of confused, radical, guilty, mentally incompetent, messed up person, lost, confused soul, very confused. I mean, I'm sure there's a array of many different things in there, from mental illness to evil to...
Let me take you to page 21.
Page
Of
21?
your survey, correct.
Next to, okay.
Do you see scapegoat about maybe a quarter of the way down or so?
I see piece of shit, sad, so bad, selfish, guilty, suspicious, troubled.
What about
Then
scapegoat? Do you see scapegoat?
I do.
Okay. A few lines down, maybe 10 lines down, do you see scapegoat, victim?
Scapegoat, victim, okay.
Okay. That would imply that some of these conspiracy theories out there are taking hold of people within this community, correct?
Among the friends, I'm sure there's people that believe that. I never said there weren't, but I don't think that outweighs the
So the
majority of
prosecution
people who
is
think he's
basically
guilty and
saying
all the other awful things. And remember, Charlie Kirk is
that the publicity goes both ways, that it's also there, it helps Tyler too.
It's about the defendant. So in the majority of opinions towards Charlie Kirk in this community are positive. So there are people that have negative.
Okay. Would you agree that negative publicity towards a victim has an impact on prospective jurors?
Not in the guilt phase, maybe in the sentencing phase.
Not in a guilt phase?
Not in the guilt phase. I don't think that whether or not they have a positive opinion of the victim implies whether or not the defendant is guilty.
I mean a negative opinion towards the victim.
Towards the victim?
Yes. Does a negative opinion towards the victim
Does that mean...
play into the mind of prospective jurors when they come in?
So if someone thinks that Charlie Kirk was a divisive figure because of what he said publicly, that the defendant's not guilty?
Sure. Could that have an effect on the verdict?
I don't think it will in this, no.
Okay. What does the literature say?
I don't know of any literature that would fit that scenario.
Okay. Question 6B asked about whether someone has what's your opinion of Charlie Kirk? 2 of the potential responses was somewhat negative and a negative opinion.
Right.
25% of the people in our community in this snapshot have a negative opinion towards Charlie Kirk, correct?
63% negative, 25%, or I'm sorry, 63% positive, 25% negative.
So 25% negative. Thank you.
And just clear, I'm not saying change of venue.
Objection,
That's when-
non-responsive.
Doctor.
Doctor.
This is not where you get to make statements. You can respond to questions, and that's something we do to make sure it's balanced. So I'll ask you to respectfully do that.
Now, question 2A reads the following. Now, I'd like to ask you about an upcoming jury trial in your community. Back in 2025, Charlie Kirk was shot and killed during an event at Utah Valley University in Orem. Tyler Robinson was later arrested and charged with intentional first-degree murder. Have you read, seen, or heard anything about this case?
Yes.
You asked that question.
Yep.
And that's where 99% of the people, there's case awareness, 99%, right?
Correct.
But that question doesn't really help us with respect to, can Tyler Robinson get a fair trial in this community, correct? Case awareness?
I didn't ask that question. That's not the purpose of the question. The purpose of the question is to identify what the recognition rate is, how many people are familiar with the case.
Okay.
That's the purpose of that question.
Okay. So it doesn't relate to whether or not he can get a fair trial. People's
No, I
awareness of it.
don't think I said that.
Okay, fairness, that's fair.
Look at his face. He's so annoyed with the prosecutor right now.
Dr. Edelman, what is your understanding?
Look,
of
he
the
gets
purpose
sassy.
of
I
this
like
hearing,
Edelman.
of the motion in question here today?
I
To the
like him.
question
Do you guys
being
like him?
towards whether or not there should be television cameras in the courtroom.
And why does it matter if there are televisions in the courtroom where there's pretrial publicity?
I like a little bit of
Because it
sass.
creates sensational, misleading media coverage that undermines the defendant's fair trial rights.
Fair
He's
trial rights.
Yes.
Okay, because of the media coverage. That's why we're here. And isn't it about
Oh,
impaneling
that's
a
why we're
jury
here,
that
the
could sit in
prosecutor.
judgment
Oh.
on Mr. Robinson? Isn't that the ultimate question we're trying to get to?
The ultimate question is, can he have a jury who has not been prejudiced and comes in with preconceived notions of his guilt that don't have case-specific knowledge, that as the trial goes on is
Hit the heart, guys,
stimulated
please.
and activated by hearing new information. There's a difference between a jury that in a community that doesn't know the evidence and hears it for the first time and maybe convicts a defendant, and a jury that comes into a courtroom somewhere else and all the information confirms what they already know and they convict the defendant. The outcome's the same, the process is very different, and that's the problem.
Okay, so it comes down to, can he get a fair trial with a jury here in Utah County?
In Utah County? Again, I'm going to keep saying this. This is not a change of venue survey. I didn't recommend for a change of venue. My limited purpose was to assess where people are getting information about this case. Are they following it closely? What sources are getting it from? And are they developing negative impressions and a presumption of guilt? And this stuff here we're talking about, this data are the baseline, and the question is it going to get worse, or are we going to stay here?
Yes, it's
But
the
we end
prosecution now.
up at the same point. Can we seat a jury to sit in judgment on Mr. Robinson? Can he get a fair trial?
Not based on this. Maybe that comes down later after, when we're closer to that. The question that this survey was designed to measure is where are people getting the source of their information? Are they seeing prejudicial pre-trial publicity? Are they following it closely? And what impact it's had so far? And what's the baseline? So leave cameras in the courtroom, and then you get more of the stuff we just walked through. And then the preliminary hearing comes out, and then witnesses testify, and all of that prejudicial stuff comes out. And then there's more negative pretrial publicity. And now we're back here in 6 months or a year, whatever it is, and we are talking about a change of venue because everybody in this community has been saturated. And the numbers you see in the survey, like guilt, is now 70, 80%, and prejudgment on sentence is over 50%, and everybody knows prejudicial details. That's what we're trying to avoid.
Fair enough, fair enough. But the ultimate risk that we're getting to is whether or not we can seat a jury here. That's why we're asking these questions about what are the effects of cameras in the courtroom.
I disagree with that. I think you can always find 12 people in any venue to raise their hand and say, yes, I
Who
think
don't-
fair and impartial.
yeah, and
Look
who
at
don't know.
Radovi,
There's people
Louisiana.
who don't.
It was the most prejudicial confession the Supreme Court could imagine. It was recorded in a sheriff's office, put on TV, and all those jurors, 12 of the jurors, all of them said they could be fair and impartial. 3 of them had seen that confession, and the Supreme Court said no. So just getting people to say they could be fair and impartial, I see it all the time. I do it as an advocate when I do jury selection. It's a common thing. It's easy to get people to say, I can set it aside. That doesn't mean they can, and there's no evidence in the social science literature that supports that they can, particularly when they have case-specific knowledge. But you can definitely explain to them the law requires you to be fair. Can you set it aside? Yes. So yes, you can find 12 people here or anywhere else to do that.
Thank you. Question 3AI, if you could take a look at that.
Sure.
This is the question about, you referred to this earlier on direct. Given what you have read, seen, or heard about this case, would Tyler Robinson have a difficult time convincing you that he is not guilty of intentional first-degree murder? You asked that question, correct?
Right, so it's based on what, yes.
Now, you would acknowledge that this question shifts the burden to Mr. Robinson, that he has to prove his innocence.
Oh, I'm sorry, which one, are you talking about? Yes, I'm sorry, 3AI. Yes, so that is a question that a judge in Tennessee came up with. Yes, and it was a measure because people would say they could be fair and impartial in the jury selection. They expressed bias and said they could be fair, and then he said, well, could you put the media out of your mind, or would the defendant have to prove that he's innocent? They go, oh yeah, he couldn't change my mind, but yes. So it was an inconsistent answer. I thought it was an interesting question, and it correlates better with other variables and surveys than can you be fair and impartial. So I use
But it does shift the burden to the
well, for the
defendant in
jurors,
that question.
they think it shifts the burden.
Yeah, he's
It's not
sassy with the
telling them burden is
prosecutor.
shifting. I don't think the question shifts the burden. I think the question is, would people already hold the defendant to that burden?
Okay. And it's your experience that that question was asked in Tennessee?
That
Potential
question
jurors?
correlates with things like case knowledge, strength of opinion, and all these factors that you would expect the question to correlate with if it's a valid, reliable question. In contrast to, can you be fair and impartial, does not correlate with any of those things. So people with a lot of case knowledge are just as likely they could be fair and impartial as people who don't know anything about the case. So that would be considered a questionable, like the validity of that question is problematic.
Okay. Take you to question 7A.
7. Yes.
The prosecution is seeking the death penalty for Tyler Robinson. If Tyler Robinson is found guilty of first-degree intentional murder, which sentence do you believe he should receive, the death penalty or life without the possibility of parole? Are you familiar that before, if Tyler Robinson is found guilty of aggravated murder, which is the actual name of the charge here,
sure,
it would then go to a sentencing phase.
Right.
On a question
very familiar with that. Yes.
of death, correct? And you're familiar that that the jury would be instructed that they would be required to weigh both mitigating and aggravating
Yes.
circumstances.
Is this a weighing state? So it's weighing the two? Okay.
Before deciding on the question of death or life without the possibility of parole, correct? Is there a reason why you left that fact out, that the jury would be told that they would have to weigh mitigating and aggravating
Yeah,
circumstances?
so again, this is a snapshot. This is not, it's, for example, I wouldn't read an instruction in a survey about the presumption of innocence, and there's like, if you look at the ASDC standards, you're not supposed to do that. This is where people are at today. It's a snapshot of their bias. It's not, oh, I think you should get the death penalty, but you'd now explain the entire system to me, so I've changed my mind. I don't think you should get the death penalty. So
Well, isn't it true that if you were to explain to them that there's mitigating and aggravating factors to be weighed, that the number of people who would support the death penalty, that would respond yes on this question, would go down?
Why do you say that?
Because you would have explained further process.
So explaining the process means that they change their opinion? Do I then have to?
If they were instructed in this question that they are to weigh mitigating and aggravating circumstances before coming to a conclusion,
the question
wouldn't that tend to depress the number of people voting for death penalty in this snapshot?
I think you'd get invalid data potentially. First of all, you'd then have to explain how to do that. You'd have to explain, well, they don't know what the mitigators are. Then you'd have to ask like death qualification questions. Well, I think I could consider mitigation. Okay, under what circumstances? Oh, if it's self-defense. Okay, well now let me ask you another question. What about a case of intentional first-degree murder? Could you consider life then? Well, no, I can't. So all of that stuff you'd have to include, which creates complexity, and that's not the purpose of this survey. This is not jury selection. Survey is not designed to be jury selection. It's not designed to be death qualification. It's where are people at today? And people have opinions, and that's what this is capturing. This person has an opinion that he should get a life sentence. This person has an opinion that he should get a death sentence. That's based on what they've read, seen, or heard about the case. That's what I'm measuring.
Understood. But important critical details are being left out before someone would be charged with making that decision, death or life without the possibility of parole, correct?
I mean, that, again, if this was a change of venue survey, maybe I would say, like, here's an important mitigator that's coming out, and then when the juror says, like, I think he should get a life or death sentence, ask a question about a mitigating factor and see if they could consider that or if they could weigh that. But that's not the purpose of the survey. And maybe if it comes to that, those are things that you would typically put in those kinds of surveys. But that's
Okay.
not the purpose of this.
Are you familiar that in the state of Utah, if someone is convicted of aggravated murder, that there is certainly the possibility of death, life without the possibility of parole, but also 25 years to life with the possibility of parole? Are you aware of that third option?
I wasn't, but sure, okay.
Should you have put that, had you been aware of it, in your questionnaire, in your survey?
I mean, I think most people would be, from my experience of doing these and getting, the bigger thing is people are fearful that life without the possibility of parole is not actually life. And they're worried that that person will get out. So giving them an option to have a shorter sentence, I don't think is going to reduce death penalty numbers. It might take the life without the possibility of parole, and some of those people might say life for 25 years. But I don't think someone with death is going to say, no, I think I would just give them life, 25 years.
Okay, but it's another option that
It would
probably
be an
should have
option.
been included.
You can, sure. I don't know if I would, knowing it. I still, maybe I would just say life, or life without possibility of parole, or perhaps.
Okay. So you've talked about how surveys like yours, they're snapshots in time, right? And surveys can't predict future conduct. Is that fair?
Well, I mean, it depends on the survey. Like some surveys may, like if you ask people about if they're going to vote in the next election.
Yeah, me
you know,
too.
And there's data there.
He's
it could
pushing
predict
back.
whether they're going to vote or not, or something like that. It just depends.
Okay. But you would acknowledge that your survey here, it's a snapshot of people's awareness and feelings in the community today.
Yes.
It doesn't represent real-world experience of what a juror would experience if they were summoned to jury and selected to be part of this jury.
So does this survey capture how a juror will react as a juror?
If they were to hear the evidence in a court of law.
No, I mean, I think I would think of this more as a snapshot of the community, and then what the social science literature tells us. So we know, for example, people who have a lot of case knowledge are much more likely to convict and process information to be consistent with how they see the world. So if they already think he's guilty and they already know all the evidence, they're more likely to interpret the evidence in a manner to support that position. So we do know that. So you can kind of look at extrapolate from the survey data in that manner, but it's not designed to predict, okay, this means these 12 jurors will disregard the evidence and acquit him or convict him or anything like that. That's not the purpose of the survey.
So the purpose is quite limited in reality.
I don't think so at all. That's your opinion, I guess. I'm sorry.
But it doesn't predict.
Are you the expert prosecutor or am
The
I?
survey is designed to see where people are at today and make an assessment of whether or not cameras should be in the courtroom or not. And you're talking about like a change of venue survey and whether jurors will be fair and impartial in a year from now or what have you. I don't quite get the connection of how that question is tied to whether there should be cameras filming things and then making speculative conjecture about whether someone's grief muscle is flexing in the right way.
So let me
Grief
ask you a question.
muscle.
I've asked this various
That
ways.
cracks me up.
What's the risk
Yes,
of
this though
cameras
it looks
being
like
in the
he's
courtroom
experienced.
if it doesn't ultimately turn on seating a fair and impartial jury to sit in judgment on Mr. Robinson?
So what is the risk of inundating the jury pool with highly prejudicial, sensational media coverage that characterizes the defendant as guilty, a monster, a psychopath, a sociopath, and so on? What's the risk of that? I think it undermines that juror's fair trial rights. And I think there's plenty of case law where even when juries have been sat and they've served and there's been a conviction, those have been overturned based off of the pretrial publicity. So obviously there were 12 people in that trial that went through jury selection, were determined that they could be fair and impartial, were able to listen to the evidence and reach a decision, and then state Supreme Courts, United States Supreme Courts, have thrown those convictions out based on prejudicial media coverage. So clearly there is an issue, and the question isn't, can you find 12 people somewhere in the county that will raise their hand and say, I can be fair and impartial? I don't think that's the standard.
Thank you, Doctor. You mentioned that these were randomly selected.
Yes.
Respondents. Digit dial, I believe you said. Did you add any numbers to your survey? Were these all truly randomly selected?
I'm sorry, adding numbers.
Did you add any numbers to be called as part of your
Be
survey?
called?
Yes.
So the survey vendor deals with the sampling. So
Okay.
I give them the county, and then
Okay.
they buy random sample. And then what they do is, so it's called replicates. So let's say they buy X thousand phone numbers, and they have to work maybe like 100 numbers, and they have to call each one like 3 times, different times a day, and all that stuff until they can reach a resolution like, no one ever answered, or it's a bad number, and then they have to open up other replicates.
Okay. Did you, as part of your survey, did you ask whether the respondents had any involvement with this case?
Involved in the case? I
Like,
haven't. I did.
like media, law enforcement, anything like that?
No.
Okay. Did you ask whether they had a relationship with anyone that was involved in this case?
No.
The respondents?
No.
Okay. What screening procedures did you take?
I'm sorry?
What screening procedures did you take?
So the screening procedure is based off of age, right? They have to be over 18 years of age. They have to be able to speak and read English. They can't have a felony. They have to be a citizen of the United States. They have to be registered to vote or have a driver's license with the county address on it.
Okay, thank you. A few more questions about your survey questions. In question 8A, will you turn to that?
8A, yes.
You asked, have you read, seen, or heard if President Donald Trump expressed an opinion about whether Tyler Robinson should receive the death penalty or a life sentence without the possibility of parole?
Yes.
Killing Charlie Kirk.
Mhm.
81% responded no, correct?
To that one, yeah.
Okay. Question 9, you asked, have you read, seen, or heard if any other public officials have said that Tyler Robinson should receive the death penalty for killing Charlie Kirk, correct? And 65% responded no, is that correct?
32% yes, 65% no.
Okay. Question 10A reads, have you read, seen, or heard if Tyler Robinson confessed to shooting Charlie Kirk? 56 responded no, correct?
Yeah, and I think that's a poorly written question because I think the bigger question is more about text messages than when I wrote it, I hadn't seen all the media coverage yet. I think confession usually is like the person verbally confessed, and this is more about text messages. So if we do another survey, I would probably change that, the way that question is phrased.
Question 10B, have you read, seen, or heard if Tyler Robinson's
That's
DNA
funny.
was found at the scene of the crime?
Mhm.
65% responded no, correct?
Yeah, I mean, I think your point is great in that we're not at a point where everybody knows all these prejudicial details, and we haven't started yet. These are the numbers of the baseline, and the idea is to prevent these numbers from going up. I think that's ideal for you and the defense and everyone, is for jurors to be not aware of all the details and facts, and that they base their decision on the evidence, not what they've heard in the media. So having low numbers on these things is a good thing.
Okay.
Well, then so
media
it hasn't
that we
affected
watched on
things
your
as
direct
much as
examination,
what you're saying.
Almost none of it was live streaming from the court proceedings, correct?
Correct.
It was third parties' commentary on the case.
Which is what worries me, not the live stream where very few people are watching.
Sure. But that's correct, right? What we were watching commentary on the courtroom proceedings.
Right, so they're taking video from the courtroom or images and then telling the story of what happened at that courtroom proceeding using the images or the lip reader to tell you what the defendant said or his body language based on his movements and all those things. Yeah, so that's what worries me. It's not a neutral, sterile, here's the live stream, no commentary. Come here if you want to see what's happening and take away. So you're educating the public. It's here's an opportunity to create sensational media
To spin
coverage
it.
of all this stuff.
For the person who
But
wants
the
to
media's
actually get
always done
accurate
that.
information, what's happening in the court, where is the best place for them to go?
I mean, to me, it's like we got accurate information for decades without live streaming. They're called journalists.
That's not
and they
true.
would come and they would write stories and we'd read about them and hear.
Journalists are.
Need to create a circus-like atmosphere, a reality show out of a trial.
What's the primary source that they would go to for accurate?
Journalists have always
accurately
been
see what's
biased.
happening in the court? Where would they go?
For who? What do you asking?
For
Always.
the average citizen who wants to follow the case.
Well, I mean, that's complicated.
That's
So,
why
like,
they
a lot of
need
people get
us.
their news on
That's why
social
the
media,
public needs us.
or podcasts, but that
Because
social
of the
media is also
biases
sharing
in our
information and
journalists.
content from traditional networks that now have to create more sensational content instead of maybe more quality content because you have to get clicks and based on an algorithm that's like focused on sensationalism and reactions. So you're trying to create content to get attention there. So,
But that person that wanted the most accurate depiction of what's going on in court would be to come to court, correct?
To come to court? That would
Yes,
be great.
and watch
Sure.
the proceedings.
I guess.
Then it needs to be open.
Yeah,
That's,
no, I
that's
agree.
where it's happening, correct? And short of that, a live stream would also provide that if someone tunes into the
Correct.
live stream.
If it was
Correct.
live stream with nothing else, because you basically have about 25% or so or less watching the live stream. So, and the other interesting thing, if you look at the live stream, it's a forum. All these people are coming to it and just spreading misinformation and conjecture about conspiracy theories and you should get the firing squad and all these things
And,
about
and
what's
those are
happening.
those are third parties that this
They're
court can't
failing.
control, correct?
That's on the live stream. That's not on third parties. That's just, if you looked at I think it was like Court TV, just the live stream of it, and you watch waiting for the stream to start or during it. It's just a forum of just spreading information that is not accurate, I would say. I'm sure we'd all agree if you looked at it, it's not accurate. But again, it's not like the majority of people are coming. If you balance it and you said, okay, well, 80% of the people are getting their information from the live stream, that's great, and very few people are watching all the sensational stuff, so the costs outweigh the benefits. But that's just not the reality. The reality is most of it is sensational media coverage that's being created from the live stream video, and then you get what we saw. It's not like people are coming to the courtroom or watching neutral live stream and then, wow, I learned so much about the courtroom process today. That's just not what's happening.
So he's saying
But
we
it's not
shouldn't
the
get to
live
comment
stream
on it and share
video
our thoughts.
That's causing this content by third parties
Well, how
that are
would
pushing it out, correct?
How would the content exist otherwise? The video of it. That is the source of the information. It's take the live stream video, and then rather than reporting on what happened, we'll say all this evidence was introduced in the hearing today, which is false. It wasn't. And it creates the impression that there's all of this prejudicial evidence, which is not evidence, and no one's ruled on any of that stuff in these hearings, when that's not what's happening. So people are being misled. They're not being
But there'll be
given
time for that in the
But
hearing.
that's created by third parties, not this camera that is behind me live streaming this proceeding today, correct?
Good point.
I guess. I don't really get the point.
What do you mean what do you mean you guess?
I don't quite understand the point. So you're saying, yes, there's all this prejudicial stuff is coming from the live stream, and it's creating all this prejudicial media content, but it's not from the live stream? It's not that guy over
It's
there?
not from the camera.
A third party is taking the live stream, which is the accurate recording of what's happening today, and then they're taking that and creating something of it, correct?
So they're taking accurate information and then distributing widely misinformation. So a small percentage is the accurate
That's what you're
information.
suggesting.
That's okay.
Hello,
I mean,
Hope.
yes, I think if you just watched the live stream and there was no commentary on it, and in a
So the
perfect world, none
prosecutor's
of those things
saying
happen.
basically,
Yes, but that's not the
if we were talking about
You say there's no limit on the third
gun
parties
rights,
using it,
the gun
that
didn't
kind
do
of
it,
defeats
the
the purpose
person
of-
did.
of the idea of
So
just having
don't
the-
outlaw guns.
And to your question,
I mean,
have
fair.
you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on Court TV, YouTube, or social media? 74% of the people responded no.
Well, that's my point, is they're not watching the live stream. They're watching the news reporting on the live stream, like on TV, like all the stuff we just walked through.
Exactly.
That's the stuff they're seeing about what's happening. They're not watching the neutral live stream. They're not just saying, here's this sterile live stream of what happened today.
Hit the
They're
thumbs
watching
up
this
and the heart
That's the stuff they're seeing.
multiple times next to the chat,
But again,
please.
it's not the live stream that's creating that
Yeah, okay.
negative content.
It's the people. That's what he's
I
saying.
feel
It's
like I'm
not the
just gonna keep
camera's
saying the same
fault.
thing, so, okay.
Yeah.
Do you agree?
Just one moment, Your Honor.
Do you agree with what the prosecution's point is?
Nothing more.
You can't control what people say about what they see. Does that mean you should limit what they see?
Can this witness be excused?
Yes.
All right. Thank you, doctor.
I'm all done. Thank you.
Chat, tell me what you think.
Yes, please. Judge, in terms of a time allotment, I have discussed with the state that they are not going to take their 2 hours. So I don't know how that would affect my time limits, if at all. But I
You
just
don't
wanted
need
to let
extra
the court
time.
know that. I think their witness is going to be very brief.
All right, I see. Well, to the parties, what are the thoughts if so you were intending to call the other doctor as your other witness.
Yeah.
The exhibits have been submitted. I believe that the doctor's, she had a 36-page report in your original motion, is that correct?
That's right.
All right. Well, again, I want to provide both parties the equal amount of time. So what I'm proposing is that we turn to the state, to their presentation of evidence, and if there is time remaining, returning to defense to call the witness as well, and see what time we have and take it from there.
I still think I have some time left on my 2 hours, or no?
Well, including cross-examination, we're about 5 minutes over.
Oh, okay.
But that's from my accounting of time. But we can proceed in that matter, returning to the
Hi,
state,
Basic.
allowing them to present evidence. And if there's time remaining, certainly we return to you.
Thank you.
Thank you.
All right, thank you, Mr. Burt. The state.
The state calls Cole Christensen.
All right, Mr. Christensen, if you'd like to come forward, be sworn in.
What do you think he's drinking?
All right, have a seat. Do we have a water bottle for him? There should be water bottles for all of our witnesses, so. Perfect, thank you. All right, sir, if you'd like to make yourself, situate yourself, and then after you're seated, pull the microphone close to you. We want to make sure that all audio is captured. All right, counsel.
You could
Are
state
we
your name and spell
behind
your
a little
last name for
bit?
the record.
Cole Christensen, Christensen.
Where are you currently employed?
I'm currently employed with the Utah County Attorney's Office, Bureau of Investigation.
How long have you been employed with that office?
Purple Crunk.
About 7 years.
Oh my gosh. Vodka.
Sorry, give me 1 second. Have you been specifically assigned to this case, the Tyler Robinson case, in your capacity with that office?
Yes,
I think we're a little bit behind, guys.
Were
with
you asked to
the
conduct research related to
stream.
media coverage in
Let's
the
see.
Tyler Robinson case?
Yes, I was.
And who made that request?
Prosecutors assigned to the case.
Did you complete that task?
Yes, I did.
Did you write a report about your findings?
I did.
Your Honor, permission to approach the witness?
You may.
I'm going to hand you what will mark as State's Exhibit 1.
Okay.
You recognize that?
Yes, I do.
What is that?
That's the report that I created from the assignment that I had.
Your Honor, pursuant to a stipulation by defense, the state would move to admit State's Exhibit 1.
Defense, that's my understanding, is that correct?
That is correct.
Thank you, it is so admitted and may be published.
And we have nothing further.
All right. Mr. to defense?
You have your report there in front of you.
Yes, sir.
Part of your report says that you were trying to, your primary focus was identifying negative pretrial publicity toward the prosecution, right?
And
Erica
I'll-
Kirk and Charlie Kirk.
Correct.
And how did you define negative publicity toward the prosecution, Erica Kirk and Charlie Kirk?
How do I define that?
How did you define that when you were doing your search?
I just defined that by the media coverage that was out there.
Right, but how did you determine, well, this is negative or positive?
Based on the way the media slanted, or the way the article or the interview went.
How the interview went?
Uh-huh.
And what did you look at? Did you look at newspaper articles?
I looked at newspaper article, traditional media sources, local, national newspaper articles, social media, Podcasts, online platforms, that type of thing.
Did you look at any of the coverage by the major networks, the electronic media coverage sites?
Yes.
And what did you look at in that regard?
What did I look at?
What did you look at?
I looked at, for one example, I looked at KUTV 2 News, I think is a CBS affiliate.
Mhm.
I found negative pretrial publicity there toward the defendant.
Toward the defendant?
Correct.
And was that generally true of the other major electronic
I
media
think they're almost
outlets,
done. We
that the
got a little
focus
bit
was on
behind, I think.
Negative publicity toward Mr. Robinson?
I'm sorry, I'm not sure I understand the question.
Was when you were looking at the electronic media coverage, and specifically the national network coverage, was the tone of that in general negative toward Mr. Robinson?
No, I think the tone of it went both ways. I think some of the tone of it was negative toward the prosecution, and some of it was negative toward the defense as well. Some of it was negative toward Erica Kirk, and some of it was negative toward Charlie Kirk.
Negative in the sense of making some derogatory comment about Charlie Kirk?
Correct. I did find that, yes, sir.
Okay. And did you do some sort of quantitative analysis in terms of how much there was in each category you were looking at?
No, I just took a sample size. So as far as, I could tell you that there's a lot out there, but as far as like a comprehensive review or to quantify it, I didn't do that. I just took a sample size.
How big was your sample size?
I agree. People are going to say more if they
Well,
close it, especially if
looked
they
at,
close it, they're going to
trending,
say a
high-profile
lot more.
media articles, whether they be in social media or traditional media sources from when Mr. Kirk was shot and killed up until the present time.
You cite in your report a study that says that 86% of U.S. adults say they get their news from smartphones or computers, correct?
Correct, yes.
What was the source of that number?
Do you mind if I refer to my report?
Yeah, sure. I think it's
Okay.
on page 1.
And the question was?
Question was, do you cite in your report a source which indicates that 86% of U.S. adults get their news information primarily from smartphones or computers or tablets?
Yes. That's according to a study that was conducted by the Pew Research Center.
And is it true that a lot of the, what you refer to as negative publicity toward the prosecution, I think you list on page
Good point, Cisco.
2, was coming from podcast sources? Candace Owens, for instance, you list.
Correct, that's one that I had found.
Erica.
High political figure statements in your report, what does that mean?
That would be, for example, some of the information we just heard, high-profile political figures that can be national or local here.
They didn't sell enough tickets for her to show up to this court
Israel
hearing.
theories, what does that mean?
Correct. Theories such as Israel or Mossad was involved in the assassination of Charlie Kirk.
You saw a lot of that on the national media?
I did see some of that, yes.
And where did you see it, say, on ABC or CNN,
Well,
where they were advocating that
Hey,
somehow
Jay.
Israel was...
No, I apologize. That was on social media.
Right. Most of the wackier theories are coming from
Correct.
fringe groups, right?
Correct. There are a lot of social media conspiracy theories out there.
And you were not making any attempt in your report here to compare how much weight someone would give to sort of a fringe report versus a national media report, correct?
No, I couldn't. I couldn't determine that.
Great. That's all I have. Thanks.
Thank you, Mr. Byrd. To the state?
Nothing further.
Thank you. May this witness be excused.
Yes.
Thank you, sir.
I'm so fringe. Y'all don't even know how fringe I am. That's hilarious.
Judge, for this hearing, this is all we have. As far as state
Oh, that made me laugh so hard.
Your time to defense.
Jay's been
Yes, so
quiet
long
for
as
a
we
little
were able to
bit.
Wrap this up today with argument as well.
All right. So just to provide some guidance, it is 3:20. We've been going on for about 2
All
hours
day.
and 20 minutes. We're going to take a brief 10-minute recess to allow people to stretch. And
Oh,
how
yeah, I
we'll
need a
handle
stretch.
this is we'll return. So we'll start oral arguments at, so we'll come back at 3:30, and we will go till 4:10 and allow each side 15 minutes for closing arguments, and then I have some matters that I need to address with the parties as it relates to scheduling a ruling from the court. So we need to coordinate our schedules because we need to end at 5 o'clock. All right? We'll go and be in recess until 3:30. Thank you.
All right. All rise. So we were a little bit behind. Oop. The stream ended 10 minutes ago. Hold on. Did
Years.
we go all the way?
to
Hold on.
life With the possibility of parole. Are you aware of that third option?
I wasn't, but sure, okay.
Should you have put that, had you been aware of it, in your questionnaire, in your survey?
I mean,
What happened? Are they done streaming?
Time to defense.
Yes, so long as we were able to wrap this up today with argument as well.
All right. So just to provide some
He
guidance.
definitely has
It's
liquor.
3:20. We've been going on for about 2 hours and 20 minutes. We're going to take a brief 10-minute recess to allow people to stretch. And how we'll handle this is we'll return so we'll start oral arguments at, so we'll come back at 3:30, and we will go till 4:10 and allow each side 15 minutes for closing arguments, and then I have some matters that I need to address with the parties as it relates to scheduling a ruling from the court. So we need to coordinate our schedules because we need to end at 5 o'clock. All right? We'll go and be in recess until 3:30. Thank you.
Okay.
So you've got 50 minutes, or you've got 40 minutes. You've got till, I think, 4:10. 15, 20 minutes.
I want to make sure we didn't miss something because it looks like on another. They don't know they're still have audio. Hold on. Okay. I'm so confused because on another one, it looks like, hold on, guys.
Do you want a snack? Or else we'll get some candy? I was just gonna go to the vending machine if you want. Yeah.
Okay, I think we're good. It just looked different in another video. Okay, we're good, guys. We're good. I panicked for a minute. Like, why they're still recording and don't know. Somebody should call them. Unless they can give us some juicy, like we can hear something. Let's see, what are you guys saying? Okay, let me see. Okay, what are you guys saying? Skip through the break. Yeah, I tried. It's live. I skipped through as much as I could. The court may impose a time delay in the live stream. Yeah, 10 minutes. $10 minutes ago? Yeah, that's what it seems like. And now it's over, or it's still like showing this. And it looks like yeah, they'll be back. Okay. Oops, I don't want to pause that. I want to mute. That's funny. They're still they're just showing this. Oh, they're just showing people's feet and conversations. What if we catch something good? Like, I kind of want to just keep it open in case we can hear something juicy. $10 minutes ago? I think we were a little bit behind, but not 10 minutes worth. Anyway, what do you guys think? Do you think that they did a good job? Who do you think's winning right now? What do you think the judge will say? We won't find out until next week, but she's going to take the weekend, take a rest. Okay, I'll tell you if I'm still listening to sound, so I'll tell you if I hear anything good. Okay. Yeah, there's probably a time delay. You're probably right. But where's Tyler? Still sitting? They must let him get up and walk around. Yeah.
I'm looping out the camera.
Like, heart, subscribe. Love it. Like it. I am going to try to do what Fearless says and go vertical. Won't that be hard though? Isn't that like harder to see, Fearless? If you go vertical, like if I show an image. Oh, speaking of image, I'll share this with you again. We got to move this guy first. Hold on. Let's remove. Okay. Out to stage. Okay. Yep. So they took Erica Kirk off of this one. They took her off. She's not going to be there. She's not making heaven crowded this time. And then we have this order. Let me see if I can. Let me get you a bigger picture of it. I can't. Oh, that won't get bigger. Okay, yeah. So the defense is asking for sanctions, and they want all of the, or not for sanctions yet, but to hold the prosecution in contempt for not abiding by the gag order. And they want to see they're asking for them to show every bit of their communication. So that is officially on the record in the courts, and they filed that yesterday. So we'll get to see what happens with that. Cisco, I don't know what all the questioning accomplished. Yes, social media influences views and people. Shocker, right? And that's just the times we live in. And we should be more informed, because before, what was going on is that the media was biased. Every, different media sources do that. And this just stopped streaming for a minute. And it says, thanks for tuning in. It ended 17 minutes ago. So the stream just stopped. So I think maybe, that's so weird. Okay. Yeah, they stopped streaming. So I'm confused about what's going on there. And it looks like Project Constitution was streaming it on X, and they're stopped too. And it's been over 10 minutes that I've seen that. So I'm going to try something else in a minute. Where was I? Anyways, the different media sources, were biased and created a problem. And so now we get to see more. I think I'm wondering if the defense just is using it as a strategy to debunk whatever's happening in the media, in the mainstream media, because alt media, except for, some of the other, ones who are on Erica Kirk's side, now we have equal. It balances each other out. It all balances out. No, Erica Kool-Aid, dang. Wait, hold on. She's on right now. Hold on. Let me show you. I'm going to share this tab instead and then I'm going to find out what's going on with the other stream because it just all of a sudden stopped.
Dressed up as compassion.
Ooh,
4 years
she's
of
got
that.
angry face on now.
You remember when we had Christian pro-life activists
No.
being persecuted for their beliefs?
Should we rewind it?
Remember when concerned parents were getting targeted by federal law enforcement just for showing up at their school board meetings?
Okay, I'm going to investigate and see what's going on with this other stream, guys.
Remember Lake and Riley? I do. Remember wide open borders? 500,000 people poured into this state alone, thanks to an administration that didn't care about stopping them. And now, 452 days into the Trump administration, look at what has already been done. Look at it. There are accomplishments. And yes, there is more to be done, but my husband and all of you fought for this, and we achieved it. Thanks. And now we have to show up again with 80 to 90% voter turnout in the midterms and fortify the red wall for the next decade. That's what we need to do. But at the same time, you have people out there who are actively trying to tear this country apart. They love to start fights, dividing us all against each other, spreading negativity, all to get clicks and influence the algorithm to maximize profits.
Oh, really, Erica?
Meanwhile, building is hard. Getting out the vote, talking to real people, spiritual revival, that's actual work. That is actual work. And my husband, Charlie, gave his life for that work. And what gets built lasts for generations long after the noise has run out of one-liners. No one understands this better than President Trump. No one. No matter what they throw at him, he perseveres in the face of adversity because the mission is too important. Because this country is worth fighting for, and he is not alone in this fight. And we are blessed to be Americans, and we are going to fight like it. And ladies and gentlemen, there is no one else I'd rather have on our side than President Donald J. Trump. God bless you guys.
Choke on it.
Ladies and gentlemen,
okay, so
I am
found
officially running for President of the United States, and we are going to make our country great again.
Okay, so I don't know what's going on. This is so weird. Other ones stopped streaming, but we've got this one. Recess till 3:30. So I don't know why did Fox stop streaming that? That's so strange. Okay. Okay, now they're back, right? Okay. But we have no sound here. Okay, there we go.
Could I have the screen turned back on, please?
They're back. That was weird.
Doctor, while we're doing that, your CV is in the exhibits here, correct?
That's correct.
You're a cognitive psychologist?
Correct.
Do you have a special area of expertise?
Let me stop you. If you wouldn't mind pulling your microphone.
Is it, can you, okay, yeah, I'm
Okay.
just not close enough, okay.
We need to put her under oath, counsel. Okay.
Good idea.
If you wouldn't mind, you can just stand right there and face our clerk. We need to put you under oath before we move forward.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
Thank you. Please be seated. All right, so if you want to get situated, you have a water bottle. All right.
I agree. People are more informed
All right,
and
Mr.
more
Burt,
involved.
returning to you. Thank you.
Thank you, Your Honor. Doctor, my question was, do you have a area of expertise within your field of cognitive psychology?
Yes, my expertise is in decision-making,
Trump slut.
judgment and decision-making, memory, and perception, and I apply that basic research to the legal system. So studying juror decision-making, specifically, I've spent a lot of time looking at the effects of pretrial publicity on jurors' decision and their memory, on how they interpret evidence, so a bunch of different things, how they deliberate. So that's what I spent predominant time doing.
When did you get your PhD degree?
In 2001.
What was your dissertation?
My dissertation looked at the effects of negative defendant pretrial publicity on juror and jury decisions. I actually looked at non-deliberating juries and deliberating juries to look at the different effects of those exposed to pretrial publicity who deliberated versus not deliberated.
Okay. And was your dissertation published?
Yes, it was.
Since that time, have you published a number of studies on the effects of pretrial publicity?
Yes, I have. And my most recent was published just recently in 2006.
How many studies?
2026.
How many studies have you published just on that topic?
I don't know. I could count them. They're not numbered on my CV. Let's say 15, 20. And I've also done a couple of reviews.
It's
book
so
chapter
weird that
reviews
Fox
have also
stopped.
been peer-reviewed.
Okay. You, in addition to the two reports that are in evidence, also prepared a very lengthy PowerPoint presentation, correct?
Yes, I did.
And you know we're not going to have time to put that on.
I understand that.
Darn, she spent so much time on that
If I could
PowerPoint.
bring up, I don't think I'm hooked up yet for some reason. See the screen, but I'm not on it.
They cut the PowerPoint? Bruh.
While
We
we're
back.
doing that, let's answer the question that
Yeah, we had to go to a
the,
local station
my
because
opponent
Fox
raised,
stopped.
which is, does positive pretrial publicity mitigate the effects of negative pretrial publicity?
And so I've actually looked at that, and I've looked at it in two different ways. One that's not realistic and one that is realistic. And so in a case like this, the realistic way, where you have a lot of negative or anti-defendant pretrial publicity come out first, we find that positive pretrial publicity that comes afterwards does not influence the verdicts. So that primacy effect, and what a primacy effect is that information that you receive first has priority. So for example, in a case where a juror has been exposed to pretrial publicity, that information will actually influence how the jurors then process the trial evidence, their memory for the trial evidence, and then ultimately how they deliberate in the jury room. And so positive pretrial publicity, if it's presented like a back and forth, like one negative defendant article, one positive defendant article, one negative, when we do that, like every other article, which is unrealistic. That is not how things work in the real world, but we wanted to see if we could remove bias. We are able to, what we call level the playing field, but when you front load the pretrial publicity with all negative pretrial publicity, then it's difficult to overcome that initial bias.
Right,
Yes.
And you looked at the pretrial
Which is
publicity in
why
this case?
they need people
Yes, I
like
did.
us
How would you characterize it, just in terms of the tone?
on the
and,
fringe. Right, Cisco?
what we just discussed in terms of negative, positive, et cetera?
So
Fringe
I
media.
reviewed all the
Maybe I should change
pretrial
my name.
publicity that was in the motion, and so I have not, there's no way a single person could review everything in this case, but I reviewed that pretrial publicity, and what I reviewed was predominantly anti-defendant. There was very little that was anything other than anti-defendant, especially early on, and in the mid parts
Yep.
of what I reviewed. It was predominantly anti-defendant, looking at the defendant, again, like Dr. Edelman said, painting the defendant in a negative light, dehumanizing language, accusations of guilt, and, basically giving your opinions upon what kind of sentence he could get. So there was a lot of anti-defendant that went to the credibility of the defendant, which is really important, but also publicity that is likely to engage the public in moral outrage, okay? Because something morally wrong has happened, it's horrible, and again, we have high-profile individuals like the president, the past attorney general, the FBI director, the governor, so a lot of people that have a lot of power and influence coming forth and saying these things about the defendant.
What does the research show when you have a situation where high authority figures, the president, the vice president, the governor, the attorney general, the head of the FBI, are putting out anti-negative publicity on the one hand, and on the other, you get these wild conspiracy theories from fringe podcasters? How does that balance out? Does the podcaster
our name
conspiracy
again.
stuff swamp or overcome all the negative publicity coming from the authority figures?
And so now you're getting into more of the conspiracy theory research, which I am somewhat familiar with, and I've looked at, and it is pretrial publicity tangent, correct? Because in this case, we can call these conspiracy theories pretrial publicity, right? Because they are a form of pretrial publicity. And the credibility of the source of conspiracy theories definitely has an effect. We have not, we don't look at the credibility so much in the research of the source of the individual, talking about the pretrial publicity, but they're published in reputable journals or, I'm sorry, not reputable newspapers or TV. And so that gives the impression that there's some authority, there's some credibility there. But actually looking at who is saying it, my research hasn't looked at that, but there's other research that has looked at credibility effects on people's willingness to accept something as true, and definitely in the social psychology and conspiracy theory research, they do find credibility matters.
So how does prejudicial pretrial publicity influence jurors? What is the mechanism?
And that really is what I looked at from the beginning, because it was already established, and I don't think anyone today would say it doesn't affect jurors, at least not in the research community. But I wanted to know how. So the first way that I looked at was how it influenced basically their memory for the trial. And so what we call source memory. So when a juror is exposed to pretrial publicity, they have two sources of information. They have the pretrial publicity that they get prior to trial, and then they have the trial evidence. They are then have to differentiate between all of that information they got before trial from the evidence they got at trial. And this is a very difficult task, and it's a difficult task because many memories are not tagged with sources. Instead, individuals have to, and this is an unconscious process, look at external factors that have been basically remembered to the side and decide, was this memory formed when I was, prior to trial, or was it formed when I was at trial? And so my research has found that jurors with a high amount of confidence believe that information that was only presented in the pretrial publicity was presented at trial. They then use that information to make decisions about guilt unknowingly. They're not aware of this because it's an unconscious bias, and that's really what I look at as unconscious biases. It's an unconscious bias, and then they talk about the pretrial publicity during deliberations as if it came from the trial, as if it is actually trial evidence, and other jurors fail to correct them for the most part during deliberations. And so we do this thing called mediation analysis, and we find that the source memory errors are actually the mediator, or actually the factor that is responsible, one of the factors that's responsible for this biased verdicts. So jurors make these errors make them more likely to find the defendant guilty, and that's one form of bias.
You were in court when the video clips were played?
Yes.
In two of those clips, the announcer says, "We heard from the hearing," and then they put out incriminating information, which actually had its source in the prosecutor's press conference. Is that the kind of source misattribution error that you're talking about?
Yes, so when I talk, and I'm sorry, I would have more time to explain if I had more time, but what I'm talking about is that you believe that the source of the information is different from the actual source. So yes, they made a source memory error where they believed the information that they were discussing actually came from the trial, the live stream, when in fact it did not. It came from the governor's press conference. So they were confusing the source, which again is something that is not unusual, and it's something that we all do.
And in the situation in the clips, they were talking about a press conference and a court appearance, and they're broadcasting that all occurred on the same day. What is the effect when the pretrial publicity is followed by a long delay, and then you have the trial evidence, and then you have more of a delay because of the length of the trial, and then you get the jurors in deliberation trying to figure out where they heard the evidence from? What does the research show about that?
So memory for source and memory for the information are two distinctive processes. And memory for information lasts longer than memory for source. We sometimes discard the source of our memories, and we keep, though, the gist, the information itself. And so if there's a delay over time, we could discard that source. But also going to source memory, what's really important here is when you're showing these clips of, the actual courtroom where, I don't know if it's going to be this courtroom, but a similar courtroom where the trial is going to take place, you have the attorneys that are going to be here, the same judge. You're not giving prospective jurors any distinctive features to hold on to be able to discriminate, well, this was something I got prior to trial, and this is something I got at trial, because the two sources now are basically entangled. And it's going to be a very difficult thing to do to try to discriminate those two sources of information.
Last area I'm going to have time for. Does research say anything about whether video or live streaming has a greater impact in terms of prejudicial pretrial publicity than other forms of pretrial publicity? And second part of that is, does repetition of the information play any part?
Okay, so first part, yes. There's evidence that video has a stronger impact. And a lot of that is because video, one, it catches our attention more, right? So you have more attention is going to be paid to video, but also it can result in more emotional responses, more visual emotional responses. And so it will be better remembered too, because visual stimuli, a lot of times it's not just the visual stimuli, there's auditory stimuli connected to the visual. It's going to be better remembered. And both meta-analyses and individual studies have shown this. And as for delay, in a trial, and I've seen this, pretrial publicity comes and goes. The best way to learn something is to learn it spaced out. And this is what we see with media that follows a case making it to trial. It ebbs and flows, and so you'll see a lot of it every time something like this happens, a hearing happens, or just before you go to trial. And so it isn't like it completely stops. And when you have this spaced learning and this high repetition, Think about what your professors told you in school. Space out your learning, repeat. This will result in very long-term memory for the information, a very strong and long-lasting memory.
Right, and so
Thank you.
it's
I'll
already
release some time
done.
for cross-examination.
It's just already done. It's already there.
To the state. Thank you, Mr. Burt.
Good afternoon, Professor.
Good afternoon.
We're talking a lot about the effects of pretrial publicity.
Correct.
On jurors,
Correct.
prospective jurors, correct? Is it true that the effects of pretrial publicity goes both ways, meaning it can negatively impact the defendant, correct?
Correct.
And it can negatively impact the state?
Correct.
Okay. In your declaration in this case and in slides that we haven't gotten to, you've referred to a number of theories. For example, pre-decisional distortion theory.
Correct.
Emotion.
Yes.
Or affective.
Thanks,
PTP,
Jay.
I
Thanks
think.
for being here.
Emotional, because affect is a little different for
A little different?
us, yes.
Okay.
Emotion is more specific.
I was looking
Thank
up,
you.
you guys,
The
as
story
we were
model
listening.
approach.
Correct.
You talked briefly about primacy effects.
Yeah.
I was looking up
belief
the views,
persistence.
like
Yes.
different
Confirmation
channels
bias.
for the
Correct.
Turning Point
Source
Action
memory
live
errors.
rally that's
Correct.
happening right now
And
for
group
Build the Red
polarization
Wall.
Or polarization
And
effects. Yes.
they're
Are
not
those
doing well.
One and the
Like,
same?
they don't have a great
Yes, they are.
turnout
They are the
for
same. And I know on a
live.
slide, sometimes it gets truncated.
Live
but they have
views.
group polarization, yes.
Okay. All of those theories, as applied to pretrial publicity, can affect both sides, correct?
That is correct.
Negatively or even positively.
And so far, a lot of the
It's
shots
not
that I
positive for
see
justice maybe, but positive
are
for the
really
side.
tight in.
Yes.
Fair enough. Thank you very much.
So I don't know how many people showed up.
If I could have you turn, do you have a binder there?
Yes, I do.
In your declaration, I believe this is tab number 6. I can have you turn to page, it looks like it starts on page.
This would be my supplemental material, because my
I think
declaration.
it's your original declaration.
Okay, so that, yeah, I have it as 5 here.
Okay, tab 5. You could go to page 6, paragraph 10.
Okay.
You're talking about a study that you, a 2018 RUVA study.
Well, this actually is not a RUVA study. This is my peer review, one of my peer review chapters where I
So
reviewed
Turning
the
Point
PTP
Action right
research
now
to
has
date at 2018.
52 people
Okay,
watching.
perfect. The second sentence in that paragraph reads, DeLuca, 1979, found that mock jurors
Fox
exposed to
has
3 pieces of anti-defendant information
4,600
were more
watching.
likely to convict than those exposed to only 1 or 2 pieces.
That's correct.
Consistent with this, Daftery, Kapoor, Penrod, O'Connor, and Wallace, 2014, reported that jurors who read a high amount of anti-defendant PTP, 10 news stories, were significantly more likely to render guilty verdicts than those exposed to a lower amount, 5 stories, correct?
Correct.
And then you indicate, conversely, greater exposure to pro-defendant pretrial publicity reduced the likelihood of guilty verdicts compared to lower exposure.
Correct. And so if they're only exposed to, one type of pretrial publicity in these cases, correct.
Okay, thank you. Pretrial publicity, again, as it applies to both the defense and to the prosecution, can persist, the effects of that can persist through jury deliberations. Is that accurate?
Correct.
Okay. And negative victim pretrial publicity can hurt the prosecution's case. Is that accurate?
That's correct.
Okay. If I could have you turn to your slides, which I think is I thought it was tab 7, but it might be tab 8.
Okay.
Can I have you turn to slide 58?
Okay.
In slide 58, you write, quote, jurors exposed to anti-victim PTP are less likely to vote guilty after deliberations than before them, close quote.
Yes, and that's a polarization effect, correct.
Thank you. If you turn to the next slide, slide number 59, you wrote,
Hey,
quote,
Sandra.
"Jurors exposed to negative victim PTP discussed trial evidence in a pro-defense manner and favored not guilty verdicts," close quote.
Correct.
Exactly, letters.
And then if I could have you turn back to your declaration in the previous tab. Page 34 of that declaration, it's paragraph 59. And I think in this paragraph,
Hold on, I thought I
okay,
was,
that's fair.
oh, again, I think I'm I'm on the supplement, I'm sorry. Just, there's too much stuff in here.
What was the page again?
Page 34.
Thank you.
34. I'm there now. And what,
Paragraph 59.
Ooh, I'll have to
sort of-
watch
this is-
that.
This is page 34 of 36, so I think you're sort of summarizing some of the
Yes,
conclusions
yes.
of your research. It states, "These findings collectively indicate that victim PTP, or pretrial publicity, can significantly distort jurors' verdicts, perceptions of credibility, interpretation of evidence, and memory accuracy, and that deliberations are not a reliable corrective mechanism. Instead, deliberations may perpetuate or spread bias, undermining the fairness of trial outcomes."
That's correct.
Okay. And again, it applies to both sides.
yes.
Okay. I noticed that
She wore
in
pearls.
in most of the conclusions or your findings in your declaration and on the slides, which again, that we haven't referred to specifically today, you couch your findings or conclusions in conditional language. For example, you write, "Information processing can be biased by information that comes before the to-be-remembered event."
Yes.
In another, in your declaration, you stated, "Live streaming of all proceedings can lead to deep-seated bias." Is that
Yes.
correct? Why the conditional language, Professor?
So as a scientist, we never prove anything, right? It's probable, there's a high likelihood, it's reliable finding, but we never say that something's definitive. We always, there could be other factors, and so we always say can, but there's an overwhelming evidence, and again, we find this over and over again, it's reliable finding that, pretrial publicity does bias how jurors interpret information, and is actually a mechanism through which, this primacy effect, this pre-decisional distortion, the story model, which they're different, but it's not important the differences. They all basically lead to the same results. They result in biased verdicts. But again, as a scientist, I would never say that I proved something, but there's a good likelihood that this will happen.
Okay. So it demonstrates your intellectual honesty, correct?
Yes.
Okay. A couple of other examples. In your declaration, you wrote, "Cognitive bias can be unconscious."
Yes.
So it's not certain, but it can be.
There's cognitive bias, and we didn't get to my slides, but I talk about explicit bias, which is bias that's easier for the courts to deal with, versus implicit bias, which is much more difficult for the courts to deal with, because jurors are unaware of their own bias.
Okay. Let's briefly talk about the studies. The majority of these studies,
That trouser,
or perhaps
Mouser.
all of them, you can correct me if I'm
That's
wrong. But your
hilarious.
studies are
That's so
based upon mock jurors and mock trials. Is that accurate?
My own studies, yes, but the research that I cite in here, there is some that is not. So there's some field research and some survey research, but my own research are all mock, what we call jury simulations, so experimental studies.
Okay. Kind of a laboratory.
Yes,
Okay. Not the real world, but you're trying to get there.
we're trying to mimic it as much as we can.
You mentioned some of the studies are survey studies.
Not mine, but individuals, it's a mixture between a field and a survey study. So yes, there's studies that go out and ask jurors, for example, something similar to what Dr. Edelman did, but it's a little different, where you ask jurors, prospective jurors in the venue where the trial is going to take place, and this is for research purposes only.
Sure.
I just had deja vu, you guys, like really bad.
Specific facts that they can recall.
Dogs barking outside,
That type of
seeing
research.
her, seeing
What
your
are the
comments.
limitations in survey studies? You
Wild
speak
when
to
it
it briefly in
happens.
your declaration, and there was even a slide about
Yeah.
that.
And so the problem with survey research is that although it might be high in realism because you're talking to people
Oh,
who might
that's
actually
amazing,
be a
Letters.
juror in that venue.
Not that you're sick.
The
Sorry
problem
you're
with
sick.
survey, that particular type of survey research is that we can't infer causation because nothing is controlled. We can't systematically vary how much pretrial publicity someone gets. We don't know exactly what they were exposed to, and so we cannot infer causation.
Deja vu
we don't measure
used to scare
anything,
me, but now I feel like
that
it's
isn't
confirmation
any
that I'm right where I'm supposed to
implicit
be.
types of bias. Instead, we look at explicit bias. We can measure, explicit, but we can't measure
So,
the implicit
Jay,
bias, the things that I measure in my
I
study.
agree.
And so that's some of the weakness there.
You mentioned that implicit bias cannot be measured, or it's difficult to identify.
It's difficult to identify, but you see it in behavior. So, for example, when I see individuals who have a very strong opinion that information was presented
Awesome.
in the trial that was only presented in the pretrial publicity, I know that they're, they have no reason to lie to us,
That's cool.
as a researcher, and they're doing this with a high amount of confidence, and that's a type of implicit bias where they
Deja
truly
voodoo.
believe that their memory is accurate, but it isn't. And then we also have this
have to look that
pre-decisional
up.
distortion paradigm where we can actually see them distort trial evidence that aligns with the slant of the pretrial publicity they were given. So in an empirical research study where we have control over everything, we can measure those things.
Okay. This probably goes without saying, but none of us can predict
Hit the hearts,
who
guys,
is
next
going to
to
be
the
summoned
chat.
to jury service in the future, correct?
Correct.
Let alone which 12 members of the community will actually sit in judgment in a particular case. Is that accurate?
Correct.
Okay. In some of your writings, you talk about, for lack of a better word, remedies, or some things that we can do in the court process to identify.
So Susan, so far,
bias.
defense is saying it's bias
explicit bias.
against
Yes.
Tyler.
And what might even
So
help
media shouldn't
with
be
respect to
allowed.
implicit bias. What
The
are some of those
prosecution is
tools that
saying
can be used?
it goes
So
both
for
ways
implicit bias,
because
the
it
bad news is
also
I really can't
leans
say that any
toward
of the tools that I
support for
discussed
Tyler
are
as well.
really- I mean, I've
So,
done research on it too. Implicit bias
prosecuting wants
is something
to
that's
have
really
media there.
hard to remedy because jurors are not aware they have it. It's unconscious bias. So how do you correct something that you're not aware of? And I could go into more detail, but I know I don't have time. Explicit bias is different. If you use, well-prepared, thoughtful
Yeah.
juror questionnaires.
slanted,
if
and
you
we need
have,
both sides.
Extended voir dire.
We need
that
all of
is
it.
individual juror voir dire, so we don't have that social desirability effect.
Mm-hmm.
You can identify explicit bias. It doesn't mean it's going to be perfect, but you have depending on what you do, you have a better chance of identifying explicit bias. It's the easier bias to deal with.
Okay. And in a case like this, a notorious criminal case like this, your recommendation would be that we
Some
that we
fringe
have
YouTube
extended
stream, Cisco.
pre-voir dire questionnaires,
Yes.
correct? Individual voir dire questioning of jurors.
Correct.
Juice.
Turning to the implicit bias, with respect to these extended voir dire questionnaires, what can be asked that may help us identify implicit bias?
So one of the recommendations, and I know it's probably in here somewhere and I don't know where, is that you need to find out the amount and type of pretrial publicity that jurors have been exposed to.
Okay.
Because even if they believe that they can be impartial, and that's they want to please the court, they want to please the judge, and sometimes they do truly believe that they can set aside bias, it's asking those questions to get at how much have they been exposed to, what is the type of information they've been exposed to, that will tell you if they're biased. Asking them whether they are biased or they can set
See you,
aside
Sandra.
bias does nothing. Jurors will say
Or
they're
Sandra.
not biased, and
How do
they
you
will
pronounce
truly
it?
believe
Is it
it.
Sandra or
And
Sandra?
we find that
Have a good dinner.
they're biased in that we look at their verdicts, and those that say they can not, they're impartial, they're not biased, they showed the same bias when exposed to pretrial publicity as those that explicitly say, no, I'm biased. I know that I can't be impartial.
Okay, so extended questionnaires that asked about someone's exposure.
Yes.
What they look at, how
Yes.
much.
Yes.
Could help identify potential problematic jurors.
Correct.
With respect to bias.
Correct.
From pretrial publicity. And it's not your opinion that someone cannot set aside their bias, is it?
When it's implicit bias, it's
Tim
very,
Crash out
very
pool.
explicit bias, but implicit bias, the problem is that in order to set aside implicit bias, you have to be aware of the bias, first of all. You have to be motivated to correct that bias, and then you have to know the amount and the direction of that bias. And those are rarely there for unconscious bias. For explicit bias, yes. But for unconscious bias, how does someone guard against how they're going to interpret all trial evidence? How does someone guard against the fact that they're now unable to discriminate what they saw prior to trial versus what they're seeing in trial? And so when they don't follow judicial instructions, because we do instruct them not to use pretrial publicity, and so when they don't follow instructions,
I think she's biased
it could
about
be that they're,
bias.
Willingly not, but a lot of times
And I
it's
think she's
because they're
unconsciously
not aware
biased
that
about
they're not following,
bias.
not following the instructions. They truly believe they're being good jurors, but they have this unconscious bias that
John
they cannot
Stamos.
remedy themselves.
Understood.
Oh, that
Thank
made
you.
me laugh. John Stamos, I had such a crush on him growing up
And
as
again,
a kid.
the bias due to pretrial publicity can go both ways, correct?
You did.
If I could have you turn
Letters.
back to your declaration. I think you're there
I'm
still.
there, yeah.
If you go to page 26, paragraph 40. In this part of your declaration, I think you're talking about the survey data that was used in support of Utah's law, creating the presumption for cameras in the courtroom. And you're talking a little bit about what California did. They did some additional research here. They used some interviews and systematic observation
For
to
sure.
perhaps bolster the basis for their law.
Correct.
The last sentence, or last two sentences in that paragraph, you wrote, each trial, witness, set of jurors, judges, attorneys are different, correct?
That's correct.
You then say there is no control over any variable, and hence there is no way to conclude that cameras do or do not affect trial
went
players' behaviors,
sideways.
memory, or decision-making, close quote.
That's correct.
Correct. Thank you. Nothing further, Judge.
Thank you. Mr. Burt.
Mr. Burt.
In your PowerPoint presentation, you kind of summarized that there are three methodologies. One is survey research for studying effects of pretrial publicity. One was survey research, right?
Yes.
Second
Correct.
was jury simulation research.
Yes.
And the third was meta-analysis.
Correct.
And do those three areas of research kind of come together with some common understandings about the effect of pretrial publicity?
Yes, they all converge on the same finding that pretrial publicity influences jurors' decisions, and that there's also another that I don't explicitly list there. There's the shadow jury paradigm, which I believe the prosecutor, he alluded to, where we looked at, I didn't look at it, it was Neftari Kapoor. They looked at it where it's kind of both a field research and an experimental study. And in their study, they found that the findings, once again, converged, depending on what the jurors were exposed to, regardless of how they were exposed to it in the real world, out, in the venue, or, experimentally, they were biased towards the side that the pretrial publicity was against. So if it was negative defendant pretrial publicity, they're more likely to find the defendant guilty. And this is, again, converges over all of the methodologies And if it was, I think in that case, in that shadow paradigm, if it was positive defendant, it was
Here's the
pro-defense.
thing, though, you
Is
guys.
the overall purpose of your study to
We're
try
7
and,
months in. The publicity
eliminate
is
bias
already
on-
what it
if
is.
possible, on
It
both ends
the
of the
damage
spectrum? In
already
other words, is your
occurred.
concern
They're supposed to
that
start preliminary
both the
hearing
defendant
next month.
and the government receive
Maybe
a
in a
fair
couple
trial,
months
not,
if they get
uh,
a continuance.
impacted by prejudicial pretrial publicity?
That's not going to
Yes.
wipe out the
A
past
lot of
7
the focus
months.
of the questioning by the state was, well, it prejudices both ways, but in either side of the spectrum, you're getting prejudgment, right?
That's
the
correct.
effect of the pretrial publicity.
He
One
does.
is prejudicing the defense, the other prejudicing the state.
That's correct. And neither, like I say, neither is acceptable in my opinion. And, obviously I think in probably the court's opinion, you don't want that bias prior to trial. You would like jurors to come in that really can be impartial and not have a favored side. And that's, when they come to trial favoring the defense or favoring the prosecution, that is going to just result in a biased outcome.
Do they get paid
I
by
want
the
to
hour?
be clear on one point. Were you suggesting that there is a way
Yes.
to eliminate implicit
Yes, I
bias
do.
by using jury questionnaires or doing open-ended questions or any other method that we know of?
It's not a way to eliminate, but it's a way to better identify jurors that might have bias. You're not going to eliminate the bias, but it might allow you to identify individuals that have bias. And so again, it's not asking, you find out that someone has been exposed to something at that point, and you find out how much they've been exposed to, what they've been exposed to. There's no sense in asking them if they can be impartial. If they've been exposed to a significant amount of pretrial publicity from one side or the other, then we can just assume that they're going to be biased.
Last question. Based on your review of the publicity in this case, do you believe that the negative publicity, and negative, I mean negative toward Mr. Robinson, has mitigated the anti-Charlie Kirk publicity, has somehow remedied the negative publicity, given the nature and the timing in particular of the publicity?
No, and again, I think because predominantly early on, and there's just a lot more by credible sources that is anti-defendant than is, anti-Charlie Kirk or anti-Erica Kirk or any, and you have to remember when we look at anti-victim pretrial publicity, especially when it comes to murder, in murder cases, because we do look at different types of cases. In those cases, the anti-victim pretrial publicity kind of points that the victim somehow was responsible for their own death because they did something they weren't supposed to do. And I'll just give you an example. For example, they came into their ex-wife's house with a gun, and the ex-wife thought that they were an intruder in the house and shot and killed them, versus, the ex-wife or the estranged wife, in this case, called her husband over so that she could, so it gives an ulterior view of what happened to the crime. So it isn't just credibility of the defendant, or of the victim, or we don't like the victim. That is not what we manipulate in these anti-victims. It makes them look like some way they maybe could be culpable for their own victimology.
Like myths about rape victims, for instance.
Yes.
A lot of the studies
Yes,
have been done in
yes.
that area.
And that has been done too, yes.
Is the publicity in this case easily characterized as pro-defendant or anti-defendant? For instance, there's some articles about suggesting, Mr. Robinson allegedly was involved in a conspiracy with others, Israel or whatever. Does that exonerate Mr. Robinson, that kind of conspiracy theory?
No, it still points to the belief that he was guilty.
He was involved.
He was just someone else
In
was
some way.
also involved too. And so it
That's
doesn't
true,
it
but-
doesn't absolve the guilt, and it doesn't
But
point away
that's what
from the
we
guilt
want, so he
of Mr.
doesn't
Robinson.
die
Instead,
for
it says
doing
there
the
might be
thing
other
by
actors
himself.
too that are
Right.
involved in this.
Not the same thing as the sort of rape victim myth
Yes.
kind of things that are studied in the
Yes.
literature.
Does
Okay,
anybody
thank you.
question whether Tyler had any involvement at all? Is that in question? Like, do you think he had nothing to do with anything?
In
Mr.
turning to
Byrd,
your
I
last
don't think
slide
that was
that you
a strong
prepared, it
argument.
was slide number 82. The title to this slide is Expert Conclusions. And number 1 reads, based on my review of the empirical research literature, the pretrial publicity identified in the defense motions and the Utah County Public Opinion
Yeah.
Survey, it is my expert opinion to a reasonable degree of psychological certainty that this case is situated within a highly prejudicial pretrial environment that presents a substantial risk to juror impartiality.
Correct.
You wrote that, right? So with respect to pretrial publicity, you reviewed the defense motions pretrial publicity.
That is correct.
You did not do your own deep dive into publicity.
No, I was not asked to do that.
Okay. If respondents to a survey were responding with words to describe Tyler Robinson as a
You think he was
scapegoat
set up by his girlfriend,
or cover-up or fall guy, would that indicate
boyfriend,
that
whatever that is,
conspiracy
and his
theories
family
that-
letters,
or theories that he was not the guy who did this are taking
or their family, the
taking hold in
Twiggs
the
family?
community?
I mean, I don't know how widespread that is, but, and again, I would need to, maybe look more at what else was said, but
I am
it
not
could. I mean,
surprised
there's a
about that,
possibility.
Basic Niche.
There are some stories out there, but as I stated, there's just overwhelming anti-defendant pretrial publicity, and what happens
Oh,
with
his
pre-decisional
own
distortion
family.
is that we actually throw away things that don't fit our initial story. So if we don't think it fits our story, I'm going to think that that's just crazy. That's just
story model
ridiculous.
approach.
Yes, the story model approach.
But if people were listening to conspiracy
really.
theories that were advanced starting the day of the charges,
It's not compelling to me.
Yeah, that's different. Yes.
that could affect their
Yes.
story model.
Yes, correct.
Okay, thank you.
All right, anything further for this witness?
No, Your Honor.
All right, thank you, doctor. You may step down.
Thank you, Doctor.
All right. So counsel, we'll turn now to closing arguments, but I do have some questions for counsel. As you know, I ultimately need to make the decision on what's being requested. And so I did have some questions for you. The court is bound by Rule 4-401.01 in
Jeff, he's
deciding whether
supposed
to allow
They
or
tell
restrict
you
electronic media
not
coverage.
to make faces or
First,
just not to
subsection
give anything.
2A states
The
that there must be a
attorneys tell
presumption that
their clients
electronic
that.
media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the electronic media coverage request is journalism or dissemination of news to the public. In assessing the predominant purpose, is the court required to consider the purpose of the requesting news media organization? For example, for today's hearing, the requesting media organization is ABC4. The court form does not require the media to represent the purpose for the coverage. So what criteria should the court apply in determining the predominant purpose of the electronic media coverage?
I mean, if my life was on the line,
Unfortunately, Your
I'd
Honor,
do
there's no
everything they told me
guidance
to
in
do.
case law. No court has interpreted this
Maybe.
rule.
I don't know. I don't
The
know
only
if I
thing
could
we
stop
have
my
to look
face.
at is the genesis of the rule, which is the final report in 2012. And if the court looks at that report,
Let's hope it
you'll
works
see
in
heavy
May.
reliance on a study, a law review article that was done by Ninth Circuit Judge Kaczynski back in the 90s. And one of the things that he emphasizes in that study, and the only indication I could see of what is meant by the predominant purpose, is he uses the O.J. Simpson trial as an example of what is not for the predominant purpose of journalism, but is rather sensationalism. And he uses how the camera is dramatizing events in the courtroom, and is the best example I saw of what could have been meant by that language. It's also noteworthy that that language was not part of the original rule when it was adopted. It was put in by amendment several years after the rule was adopted, I think in 2015, and I did diligent search on this. I could not find any indication in the Judicial Council proceedings or anywhere else of what was meant by this. So it's kind of an open question of how the court goes about and interprets it. I don't think it's governed by how the media represents themselves. I think it's more governed by the
He's just
substance
not
of it.
into
Is
it.
it sensationalistic? Is it more focused on advertising? A lot of the coverage you'll see on the clips, even the live stream coverage, has commercial breaks in it. And one of the factors that the Supreme Court cited, Estes, Maxwell, those cases, is the effect of having court proceedings that include product advertisements and the kind of disrespect that could result from that, from putting the court in the position of at least appearing like they're advertising goods here as opposed to doing justice. So in the absence of any indication, and this language also is unique to this state. I could not find it anywhere else in terms of what that meant. So my best answer to the court of the question is that I think the court has to look at, is it serving an educational purpose? Is it, and that's what journalism is. You're reporting the news, you're not creating it. You are reporting on what's happening in court. You're not making arguments for the prosecution to show that Mr. Robinson is guilty. And one of the things we've tried to demonstrate in the hearing today is that at least the electronic media, the predominant theme there is advancing the prosecution's side of the case. It's not educational in nature. It certainly is affected by a profit motivation, but more importantly, it's sensationalistic.
What?
And it's prejudicial.
For ads.
And I would say that is not within the scope of the
Commercials
language
go
that the court is
during-
talking about.
All right, turning to the state.
Cable TV news and all. What?
Judge, I don't know that I have a whole lot to respond to because
ads,
these are unknowns. But the language of this, so there is a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings where the predominant purpose of the coverage request is journalism or dissemination of news to the public. So when I first think of that, I mean, we have all kinds of media coverage that is probably not journalistic in nature. Some of the podcasts, some of the different streamings that can occur that we can find on the internet, online.
Newspapers have ads.
I don't know that you would couch those individuals as journalists so much, but ABC4,
I beg your
KSL
pardon.
News, these are journalists that are live streaming these proceedings. The
fringe
the
journalists,
difficulty here that we're
mister.
confronted with is what is being done with that coverage by third parties, which can't really be controlled. But a news organization that comes in to actually live stream these proceedings, they're then streaming those proceedings to the public. It's very educational.
It is.
It's very newsworthy.
We're
It's
learning a
disseminating
lot.
the news.
Yep.
And so I
Agreed.
think if the request from the court was from a YouTuber,
Hood frags.
some sort of broadcaster, or some sort of podcaster, there may be problems there. But when it's coming from a traditional news organization, they are in
No.
fact disseminating this news. But,
Okay.
it's about the best I can give you right now, Judge.
All right,
What?
just two more questions and I'll ask you first.
Mm-hmm.
Subsection
Okay, you have to
2D
have
of
a
the rule
big-
states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. The court reads this as
Yep.
requiring individualized findings for
And
each
very
proceeding
commercial.
rather than permitting a blanket order prohibiting coverage. Is that your understanding?
I believe that is accurate, Judge. That is my understanding, and that's why I think a request to just simply eliminate electronic media coverage in this case is premature. It's not warranted. there are going to be times, probably throughout these proceedings, where
Yep,
a hearing
exactly.
should be closed for safety purposes. Or if there's, some sort of controversy that could prejudice one side or the other. But just a blanket exclusion of the media, I think, would go well beyond what this allows for.
All right, and so is this what the court must undertake this process for each hearing?
Well, I think the court has sort of a foundation of the issues before it, has an idea about what the effects of pretrial publicity can be for or against either side, possibly even both. We didn't discuss what happens to people who look at both sides of the slanted coverage, what the effect on that individual is. But I would suggest that the court can take what it's learned through these hearings, the evidence presented here, and apply that to the proceedings moving forward. And if we have to reconvene or if there has to be further argument, we can make those arguments, and the court has a basis to draw from now.
Thank you, Mr. Commander. Mr. Burt, the same question posed to you. Subsequent 2D of the rules states that any reasons found sufficient to prohibit or restrict electronic media coverage shall relate to the specific circumstances of the proceeding rather than merely reflect generalized views or preferences. So the court reads this as requiring individualized findings for each proceeding rather than permitting a blanket order prohibiting coverage. Is that your understanding?
No, it isn't, Your Honor, because I think what that section is referring to is you can't base a finding under the rule based on general concerns. It's got to be related to the specific publicity in this case. And the reason I read it that way is if the court looks at 2A, it says the judge may prohibit or restrict electronic coverage in those cases. It doesn't say in those proceedings. It says in those cases, as if the court can make a ruling regarding the entire case. And that reading, I think, makes sense in terms of the practicality of having the court have to revisit this issue every time we have a court proceeding. I think A points in the direction of the court being able to make a finding that applies to the case as opposed to a particular hearing or proceeding, and D directs the court that when you're considering the issue, you shouldn't take into account just generalized concerns like prejudicial publicity in general is harmful, but you have to look to the particulars of the case and decide in this particular case, is there a reasonable likelihood that the defendant's fair trial rights will be jeopardized under the first factor. There are other factors, of course, but I think that is, or for instance, on the privacy concerns. I think D is calling you to look at not in general, well, juror privacy or witness privacy may be jeopardized. That's a general concern or a general view. What the rule is saying you should do is don't look at general views or preferences. Look at whether the witnesses or potential jurors in this case could be impacted in terms of their privacy rights. That's the way I read the rule.
All right, one final question, Mr. Burt, I'll start with you.
Sure.
So the court's not limiting argument on the factors set forth in Rule 4-401.01. However, I would like counsel to address one specific factor, 2BV, which allows me to consider whether electronic media coverage will create adverse effects greater than those caused by media coverage without recording or transmitting images or sound. Even in the absence of electronic media coverage, the media retains a First Amendment right to observe and report on the proceedings. Is there evidence before me that would assist the court in comparing these two circumstances?
There is, Your Honor, and in particular, the report set out in great detail in Dr. Ruva's declaration, and we didn't have time to explore this in detail here, but the declaration indicates that the source of the media does matter, that electronic coverage has a greater impact than print media because it's more visual. And from the perspective that Dr. Ruva talked about, this source misattribution theory, the visual of the courtroom is much like what a juror is going to be hearing during the trial. So in that scenario, they're much more likely to make the kind of source misattribution errors that cause jurors to have this implicit bias. They're thinking, oh, I've heard this before. And what they may have heard before is the kind of coverage we saw today where the court proceeding is in the background. They've silenced what's going on in court, and the media talking heads are saying, let's look at the text, let's look at the confessions. So the danger here is that they're going to confuse those two and not know that they're confusing them. And so that comes from the visual looking at the images. You're not going to get that, according to Dr. Ruva's declaration, from print media alone. And she cites a number of studies on that issue. So I think there is evidence before the court on that.
Well, then that creates another category, which is audio, because the audio is available to anyone if it's not a closed hearing. And so walk me through the scenario if audio is played and then, as you described, media is doing what you just described with the audio clips being played and then them commenting on that.
I think the situation is not comparable to the video scenario, because in the video, they're using it as a backdrop. It seems unlikely that they can use an audio backdrop, silence the audio, and make the kind of commentary that they're making here. They're using those images as a dramatic way to say, look, we're in court, and the announcer's saying, and we heard during the hearing the text messages. Well, that didn't happen, of course, but how would you do that with an audio? You couldn't silence the audio and have the commentators putting in that prejudicial content. It's I think, qualitatively different.
Okay. All right, Mr. Grunander, I'll pose that same question to you and happy to repeat it if you'd like.
The only way to get the best information out is to have all the information out.
Certainly the media could, certainly an outlet could grab the audio and splash something up on the screen, which we see as well too, that could prejudice one party or the other.
Newspapers,
So I think
boomers
the court
stuff,
raises
for
a
sure.
good point that the audio is going to be always available. Certainly, I think that intense coverage of any proceeding, there's a greater risk, right? I think that that's fair to say. One thought that came to my mind, though, is that even perhaps a middle ground, if the court has concerns here, is the WebEx broadcast. That would give the court control of the camera. There couldn't be zooming in and zooming out, stuff like that. But there is a greater risk with additional coverage.
All right.
I would say.
All right, so we have about 24 minutes, and I realize that your closing arguments, well, they are important, and so I'll give the parties an option. You can have a very brief closing, or if you wish to submit your closings to the court for consideration in written form, I'm happy to entertain that, so you're not limited to a time constraint. What are the thoughts of the parties?
Judge is like, can this be done over with now yet? Give it to me in writing.
Submitted to the court, I think it's getting near the 200-page limit of written arguments in front of the court. And the hearing has provided the court, I think, with some sense, but the real important stuff is in the declarations that were submitted in support of the motion. That declaration is thoroughly addressed in the written motion. So I'm not sure it would be helpful for the court to burden you with yet more paperwork.
200 pages.
But I think the court has the tools in the written submissions. I do want to, in the brief time I have, say a couple of things that I wanted the court to focus on that have come up since we filed the pleadings that I think are important. And I think if the court could give me a little time to do that, then I'd be satisfied with keeping within the time limits and submitting it based on the pleadings that are in front of the court.
Sure. How much time would you like?
I'll try and do it in 10 minutes.
And how about 5?
5.
Deal.
All right.
One of the things the court, when we were discussing this issue the last time, the court asked me whether the Estes case had been overruled. And I've been thinking a lot about that after that, and I'm not sure I answered it satisfactorily. I said no, that there is still this notion of prejudicial pretrial publicity in high-profile cases, which this is. I stand by that argument, but I went back and took a look at Utah Supreme Court cases since Chandler was decided in 1981 to see whether there was any sort of hint in Utah cases suggesting that Estes was no longer good law. And I also looked just in general at how many times that case has been cited. It's been cited as of yesterday about 4,200 times, which is not generally how overruled cases are treated. It's not listed in Westlaw as overruled. It's cited a lot. And the Utah Supreme Court, after Chandler was decided, cited it 3 times. Or they either cited Chandler or they cited Estes in 3 opinions. One of them was when they were considering modifying the rule in Utah, which back in the 80s prohibited in-court coverage. And in 1981, the Utah Supreme Court published a brief memorandum of opinion about that proposed modification. And the court cited Chandler in its discussion. And the proposal was that the prohibition be eliminated. And the Supreme Court says, the members of this court are unanimously of the view that Canon 3's prohibition against televising, broadcasting, or recording of judicial proceedings should be reaffirmed, and that the petition for modification of those provisions should be denied. We are not satisfied that the balance between the interests of news reporting and the interests of a fair trial represented by Canon 3 would be improved by the proposed changes. Experiments underway in other states may yet suggest appropriate modification to the canon on the subject, but for the present, we remain unconvinced that change is warranted. And they note that Chandler was decided before they published this opinion. So they recognized that Chandler was on the books. They did not go down that path. And so that's the first time they cited it. They cited it again in a case called State versus Vasquez, 1983, 672 Pacific 2nd, 1254, where they discuss it in the context of a juror misconduct claim for jurors who had, despite the court's instructions, had read the pretrial publicity. And it's cited for the, Estes is cited for the proposition in Vasquez that it is axiomatic that a defendant is entitled to a fair and impartial trial based on the evidence presented to the jury without the jury being influenced by information from outside sources. See Shepard, Estes, and State versus Pierce. And then the Supreme Court decided, reference Estes again in a state called State versus Bishop, 753 Pacific 2nd, 438, decided 8 years after Chandler. And they cited it again in Estes in a case decided the same year, Lafferty, 749 Pacific 2nd, 1239. So I don't think Estes has been overruled. And the one thing I wanted to stress to the court, I know the court from past rulings is inclined to keep these proceedings as open as possible. I know the court's frame of reference has been the rule that you just referenced.
The law's not
But
different.
As I tried to stress
so
in the
until
motion,
it's different.
there are federal constitutional rights involved. And the federal courts take a much different view of cameras in the courtroom than the state courts, both in Utah and everywhere else. And the general trend of the federal decisions has always been they don't want cameras in the courtroom. And so sooner or later, if there's a
States
conviction
are
in this case,
independent with their own laws for a
this case is gonna end up in
reason.
federal court. And one of the issues that'll be raised if
Didn't
this
just
motion is
say the
denied
threat
is,
of
was
it
that
being
a proper denial?
sent to the appeals to the federal
And
court.
I cited to the court in the original motion, a case from the 10th Circuit that says, in a clash between the First Amendment and the defendant's fair trial rights, the defendant's fair trial rights must always prevail. So this case will be litigated if there is a conviction in the 10th Circuit. You have 10th Circuit authority saying if there is a clash, and there certainly is, between two constitutional rights, then you always have to opt in favor of the defendant's right to a fair trial. Now, in this case, we don't have a clash of constitutional rights because the federal courts have said and been clear for years that there is no constitutional right to have cameras in the courtroom in televised trials. So we're not talking about the clash between two constitutional rights. We're talking about the clash between a federal constitutional right and a state rule presumption that applies only if the nature of the publicity is news and not sensationalism. And the other factors that the court has to consider under the rule are not met. So however the court balances those factors under the state rule, the court still has to contend with the federal constitutional issues here. And those issues and the rules there are much different, and they argue strongly in favor of granting this motion. The last thing I want to say to the court, and I know I'm close to 5, if not over it, is
I think you're over, Bert.
one of the factors under the rule, if the court just is going to balance under the rule, is privacy concerns. And we have privacy concerns of witnesses who have expressed to the court that they do not want to be televised. We do not know the privacy position of the vast majority of witnesses who will testify in this case. So whatever the court does here, I don't think the court can make a blanket ruling that says you will never reconsider whether to take cameras out of the courtroom for witnesses who don't want to be televised. I think that may have to be something the court's going to have to deal with down the line. And similarly, I don't think the court in ruling here is excluding the possibility that certain hearings would also have to be subject to possible closure, most relevantly the preliminary hearing, because
What happened? What happened?
favor of closing the hearing. So we presented the court with a broad argument here that cameras should be excluded, especially under the federal constitutional test. But however the court rules, I don't think this issue is going to go away unless the court just says, I've looked at the publicity, I've balanced the interests at stake and all things considered, and given the fact that we still have a chance to keep this case in this county, because the survey shows that we don't have overwhelming prejudice here. There is still room to take action to try and stem the flow of the kind of publicity that we've seen so far. And that's why we're urging the court now to step in and do the one thing you can do. You can't control the witnesses, you can't control the media lawyers who have spoken out of court, you can't control the prosecutors who have also spoken out of court about things that perhaps should not be spoken of. But the one thing you can control is, and the U.S. Supreme Court has said you can control, is time, place, and manner restrictions. You can say to the electronic media, you are certainly free to attend. You are certainly free to write about anything you see in the courtroom. The court is open to all. That serves the function of open access, transparency. But because of safety concerns, privacy concerns, fair trial concerns, I am balancing the factors in favor of closing the hearings to further electronic coverage.
Thank you, Mr. Burt.
Thank you, Judge.
Mr. Gernander.
Thank you, Judge. Your Honor, mischief lurks
Hi,
in the
keep
dark
focusing.
or in secret.
Haven't seen you in a minute.
That's at least how many people view the workings of government, even the courts. And while this is primarily the media's fight here, we do not represent the media. We strongly support open and transparent proceedings in this case so that the public will trust the process here. There are conspiracy theories that abound. There are questions being raised, and the best antidote for falsehood is the truth, is accuracy.
Yep.
It's the actual real
Transparency.
proceedings.
Exactly.
And that's why we
Thank
favor opening this court and allowing the cameras in the courtroom. Again, as I said before, an option the court could
Agree.
undertake is broadcasting these proceedings via WebEx. In 1981, the Supreme Court squarely held in Chandler that states may permit cameras in courtrooms, and that doing so does not, without more, violate due process. The court explained that the mere presence of broadcast media does not inherently render a trial unfair. Quote, the court said, an absolute constitutional ban on broadcast coverage of trials cannot be justified simply because there is a danger that, in some cases, prejudicial broadcast accounts of pretrial and trial events may impair the ability of jurors to decide the issue of guilt or innocence uninfluenced by extraneous matter, close quote. It is a challenge. It will be a challenge in this case because of the pretrial publicity in part, for and against the defendant, for and against the state in identifying impartial jurors. But it can happen, Judge. And I don't believe that prejudice has been shown. Irvin v. Dowd, a 1961 Supreme Court case, gives the standard for impartiality with respect to jurors who've been exposed to pretrial publicity. That court said, it is not required, however, that the jurors be totally ignorant of the facts and issues involved. In these days, mind you, this was 1961, in these days of swift, widespread, and diverse methods of communication, an important case can be expected to arouse the interest of the public in the vicinity, and scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. This is particularly true in criminal cases. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court, close quote. That was the reason I kept asking the first witness about, at the end of the day, yes, I understand this is about cameras in the courtroom, but at the end of the day, the question is, can we seat an impartial jury? Can Mr. Robinson receive a fair trial? And the evidence indicates that he can, Your Honor. In looking at the survey findings from Mr. Edelman, and I'll point to just a few that I asked him about towards the end of my cross. Well, the question about, whether they had heard about President Trump saying something about the death penalty or life without the possibility of parole. 81% said no. Other public officials having commented on that, 65% no. Whether they'd heard about a confession from Tyler Robinson, 56% no. The question of DNA, 65% no. And ultimately the question of, have you seen any video footage or video clips of the courtroom proceedings from Tyler Robinson's case, for example, on court TV, YouTube, or social media? So all these large different media mediums, and 74, I believe it was, 74 responded no. That is significant, Judge, because for argument's sake, if we forecast picking a jury in this case, and we were to choose 1,500 prospective jurors to summon into court,
Judge looks like he's gonna fall asleep.
1,110 of them
Wake up.
would not have
Look alive.
viewed courtroom proceedings because of the live streaming in this case on YouTube or social media or elsewhere. So that's the ultimate question before the court. Today, the question before the court is whether or not the defendant can receive a fair trial with the current coverage that's going on. Whether his right now is compromised and it's going to be compromised in the future, we can't predict that with any certainty, but there has been a substantial amount of coverage to this point. And it goes both ways, Judge.
Yep.
It's clear from this survey that there are negative feelings towards the defendant, which can help negative feelings towards the victim, which can help the defendant. 25% of the public responded negatively about Charlie Kirk. So at the end of the day, again, mischief lurks in the dark or in secret.
Yes. Yes, it does.
Let's shine a light on these proceedings, a
Yep.
bright light, so the public can have confidence in what happens in this courtroom. Thank you.
Standing O, yes.
Thank you,
Let
counsel. I
us in.
appreciate
Let us
the
in. Let
arguments
us
and
in.
evidence presented today. I do want to read a brief statement, and then we'll go to scheduling when the court will make its ruling. The court takes this opportunity to remind all counsel that if any counsel is found to be in contempt of the court's pretrial and trial publicity, it's order docket number 23, and as amended in docket 242, that attorney faces possible sanctions ranging from orders to attend CLEs, public admonishments, and fines up into include jail time, removal from the case, and in the most serious instances, dismissal of that case. These sanctions do not address the consequential nature, the natural consequences that arise when the court must take time away from the regular course of case matters to determine if an order to show cause is appropriate, and possibly hold an evidentiary hearing to determine whether contempt has occurred. That being said, counsel would do well to carefully consider their decision to make extrajudicial statements that have a substantial likelihood of heightening public condemnation of the accused, and should consider this before doing so. With that, let's turn to scheduling. Counsel, it looks like the next availability of this court to do a WebEx ruling would be May 8th at 3 p.m. And what is the availability of counsel?
So he's going to rule May 8th?
State's available.
Dang, you need
Thank
that
you.
much time?
Yes.
It'll be WebEx, not in person.
That was 3 p.m., Your Honor.
3 p.m. on May 8th
And that would be WebEx.
on WebEx.
We're all available on that date and time.
Thank you. And counsel, before we adjourn, I encourage you to keep your foot on the accelerator in regards to this case. I acknowledge the hard work you're doing. I encourage you not to let up. And the court will issue its ruling on the two issues in regards to a continuance of the preliminary hearing and the motion before the court today. Ms. Nestor.
Your Honor, with respect to the hearing on May 8th, we would again request that our client appear via WebEx with no video.
Thank you, Ms. Nestor. I appreciate that clarification, and that will be the case. All right. Anything further before we adjourn today?
Hey, nature's nectar.
Thank you to all parties. Court is
I
now
don't
in
know.
recess.
Did I miss something in the chat?
All right.
Well, there you have it, guys. We didn't get to say bye, Candace, today like we usually do. Because it wasn't Candace. Okay. Gosh, I look a mess, you guys. Whatever. It is what it is. All right. So I was looking up on Ask Grok the last couple high profile cases where they asked for no cameras, and they did ask for no cameras in Brian Koberger, the Idaho student murder case. The defense filed motions to remove and limit cameras, citing concerns that media focus on the defendant was prejudicial and the photographers weren't following decorum rules, because there were decorum rules. But so far, the media for this court is following the decorum rules. The result was that the judge banned independent news media cameras from the courtroom during the trial. And the court itself operated the controls of the camera and the live stream. So didn't they do that during the Karen? No, wait, I'm trying to think. I think that was court run. I can't remember though. And then the other case was the Richard Allen Delphi murders case in Indiana. The trial concluded in 2024. The judge denied the request for cameras in the courtroom for the trial and sentencing. No cameras were allowed. And let's see. Media and public had no video or still photo coverage inside the courtroom, only sketches. So that's that. Let's see. Netflix, I'm sure they don't have an agenda. Well, yeah, I don't know, but it was a good documentary. So it was really good. This woman felt really drawn and led to, she had been involved in the same sort of abuse. She felt like she needed to go to that town where they operated over in Arizona. It's on the Arizona-Utah border. Anyway, she felt drawn to that community to help set them free and to get them free. So they took cameras. They made friends with the man and the people, and they filmed for a year, and they ended up busting them. And some women and children were free from that. And due to her work and her persistence in that, she worked with the FBI. And yeah, it's really good, actually. So if their agenda was to break up that, in that case, I feel like, it did shed some good light on it. Anyway, okay. Check back another time. I don't know what that was about. Sorry, what happened there? Okay. The hearing is, so somebody was asking about that. Let's see. It's court. It just keeps going and going. That was long. I don't think I would have made it being in person, and after flying and all that, I would have been even feeling worse than I feel now. But Tyler does have really thin hair. He sure does. He does have thin hair on top back there. People have been telling you to start a cult. But I'm not mean enough. Yeah, you have to be kind of sick to do that, right? Like TPUSA. Start a cult. Oh, goodness. Okay, that was long. And I'm glad you guys were here with me. I'm glad that you came in, Fearless, that you left Trigger Smart for me. I feel so happy and so privileged. Anyway, thank you guys. Just marry into British Lord's family and start a YouTube. There you go. Do that. That's cult enough. Okay, guys, I'm going to go put more warm compresses on my eye, get some rest. Hopefully this headache will lift. Focusing. I hope that your tooth pain does get better and lifts that. For you over the weekend, that's a long weekend to have pain. Okay. Thanks, guys, for being here, and we will see you most likely on Tuesday. Okay? See you later. See you soon, everybody. Bye-bye. Have a great weekend. Good drugs. I wish I had good drugs. I don't. Bye, guys.
This is a better life. From scars to stars, from pain to bulletproof, to reach a better life. A better life with you. Talking news, pop culture life, love and scandal, heart to heart. Teresa Bell. no playing small. We rise, we fall, we laugh, we do it all. A better life is one brave call to raise a better life. Let's build a better life. Let's build a better life. A better life. To raise a better life.